asked the court to help the defense in this respect. Last week, when the jury was deliberating, and we ended up being here later than normal, and Mr. Toledo was taken back to the jail. They didn't save a hot meal for him. He ended up just eating cold bag meals the whole day. Based on what you said earlier, we'd ask if Your Honor be willing to contact the jail and have them hold a hot meal for Mr. Toledo whatever time he gets back tonight.
I'll see what I can do.
Thank you.
One other thing is our last witness, Your Honor, Dr. Meadows. I contacted him over the lunch break, and he indicated to us, basically giving him an idea of what the schedule would be like today and the anticipated schedule. He indicated to me that he had a commitment at 6 o'clock. I talked to Mr. Nielsen about possibly also taking him out of order. So, as Your Honor had indicated to us, you wanted to finish with everybody today.
I do.
And so the only way to make that happen is to go ahead and do Dr. Holder, then Dr. Meadows. I've asked him to come on to the courthouse, and so I don't know if anything need to be heard about that or not.
Get him here.
I mean, it does disrupt our flow. I understand that.
Well, yeah, get him here. You got your witness ready?
Yes, sir.
Okay. Ready for the jury?
Well, it's not my witness now. It's the state.
The state witness? Okay.
Ready.
You ready for it? Okay, bring the jury in.
Call the jury.
I'm sorry, yeah, I'm going to tell him.
Your Honor, the jury is in the presence of court. See the jury box.
Thank you, everyone may be seated. Welcome back. I do want to make an announcement. Number one is that due to me pushing along, we'll have to take some witnesses out of order, and the next witness that is testifying will be testifying technically in the middle of the defense's presentation, but it's only done for the purpose of keeping a schedule. So state, call the next witness.
The state calls Dr. Lawrence Holder.
Yes, I do.
Thank you. You may have a seat.
Inquire, Your Honor.
You may proceed.
Thank you, Your Honor. Good afternoon, sir.
Hello.
Could you introduce yourself to the jury?
I'm Dr. Larry Holder.
And how are you employed, sir?
I do several things, but I work part-time at UF Health in Jacksonville. I'm on the faculty and a professor at the University of Florida. In that capacity, I teach and see patients, and I do educational activities for drug companies and others, and I do reading in terms of core laboratories when imaging tests are used for drug trials to see if it's efficacious or not.
Okay. You are a physician, is that correct?
Yes.
And is there a particular area in your career that you've specialized in?
Yes, I'm board certified by the American Board of Radiology, and I'm also board certified by the American Board of Nuclear Medicine.
Okay. Well, can you tell us what radiology and nuclear medicine is?
Radiology is imaging, and I think everyone is fairly familiar. You've had a chest x-ray or you've had a CT scan, and it's an imaging technique in which x-rays pass through the body, images are obtained, and the radiologist interprets those images, so other variations. Nuclear medicine is similar in that it uses energy, but the energy is from a radioisotope, a material that's injected into the body, and it goes to various places in the body because of its characteristics. Some go to the kidneys, some go to the liver, some go to the bones, and when they get there, they put out blips of energy, and we detect that energy and make pictures, and because it's digital, we can also make measurements.
And is that generally called a PET scan?
That's general nuclear medicine. PET scan is just slightly different. You heard a lot of stuff earlier. It uses a slightly different isotope. The detectors are relatively similar. Energy is coming out of the body, and it's detected.
Okay, and are you board certified in nuclear medicine?
Yes.
Okay. Can you tell us a little bit about your background, education, experience as it relates to this particular field?
Well, after I went to college, I went to Vanderbilt University, then I went to medical school at Washington University in St. Louis, and then after interning, I was at the Radiological Health Laboratory associated with the Nevada test site for 2 years, and then I did a residency in diagnostic radiology, and I did a fellowship in nuclear medicine at the University of Cincinnati. And then I went into practice, and I was in Baltimore for 30 years, and then I'm here.
Oh, and where did you work at in Baltimore?
I was at a large community-type semi-academic hospital affiliated with Johns Hopkins, and I was a assistant professor there. And then I went to the University of Maryland to be the head of nuclear medicine. And then when I wanted to slow down a little, I came to the University of Florida at Jacksonville, and I've been there 17 years.
How long have you practiced as a medical doctor, including the time you spent in diagnostic radiology and nuclear medicine?
Well, I graduated medical school in '68 and took my first job in, I think it was 1975, so 40-some number.
Okay. Well over 40 years.
Well over 40 years.
Now, is it the case that, Dr. Holder, that most of your practice has been dealing with sort of actual real-world patients, people you've treated in this field?
Yes. Everything I've done has been with patients. We've written a lot of papers and done clinical research using the information on those patients' examinations, but it's all been on real patients.
Now, are you a licensed medical doctor in the state of Florida?
Sure.
And are you a member of any professional organizations?
Yes, I'm a member of the American College of Radiology, the Radiologic Society of North America, the Society of Nuclear Medicine. I think Florida Medical Society, that's about it.
All right. And we don't have to go into all of your publications, but you've been published in this field, is that correct?
Yes.
And you've also held teaching positions in this field?
Yes.
Now, have you ever, I know you said you're board certified in this field, have you ever had an opportunity to be on a board that determines, makes determinations of other doctors who want to be board certified in this field?
Yeah, the American Board of Radiology does that, and I've been an oral examiner. We stopped oral examinations about 2.5 years ago, and now it's all additional written only. And for the American Board of Nuclear Medicine, I was actually on that board and chairman of the board of the American Board of Nuclear Medicine, and we gave the examinations in that specialty.
So not only are you board certified in the field, but you are one of the people that would determine what other doctors became board certified?
Yes.
Now, I think we've already we've heard some discussion about how PET scans work. Is there anything in addition to Dr. Wu's testimony concerning how PET scans, what they are, how they work, that you think is important for our jury to know?
I'm not going to go through the whole stuff.
Right.
The only thing that I think you need to be aware of is we are looking at cells that are metabolizing things or are having other isotopes or tracers go to cells. We use the appearance and the measurements to make certain diagnoses, but it's the metabolism that we're looking at.
Now, has PET scan been around for a while, or is it relatively new?
No, it's been around for a long time. There were initially, about 30 years ago, some research scanners that people use, mostly with the brain because it was small and you could do it. And then about 20 years ago, there were PET scanners that would be able to look at the whole body. And then about 15 years ago, all of the new PET scanners are PET-CT combination scanners, and now they're coming in with PET-MR scanners. The only difference is that you saw a picture of somebody going in a tunnel for a PET scan. When you have PET-CT, there's a tunnel and one tunnel right next to it, and you're on the same stretcher that goes in, and since they're registered, it allows you to put the anatomy on top of the physiology. The anatomy of the CT and the physiology of the PET scan can be registered.
Now, what are the general uses today, the most common uses of PET scans that are generally accepted in the clinical scientific community?
Okay, the most common is for tumor imaging. Someone has prostate cancer or breast cancer, and they're wondering whether it's spread. You use a PET scan because tumors are very metabolically active, and we can see that. I won't go into the physiology. We use it for certain cardiac things where we use, again, we do other imaging for cardiac, but PET has an advantage in one or two areas. We use it in the brain in several areas. The absolutely most common is for dementia, and you've heard about Alzheimer's dementia. There are a couple other accepted areas in the brain used less frequently. One is if someone has had surgery or a penetrating injury of the brain, and then they don't get better as fast as you'd like. You take an anatomic image, and you can't tell whether it's a scar or whether it's an active tumor, and so you can do a PET scan because scars don't have very much metabolism, and tumors do. There's a tracer that we use for Alzheimer's disease, and the last one, used almost primarily in children, is for preoperatively trying to find the source of a seizure. Because if the seizure can't be treated medically, they often have to go in and take out the list of little abnormal and causing all these circuits to fire. And those are the accepted areas that are done and for which we get paid.
Okay. I think we had a little bit of an explanation of this before, but what is the difference between, say, a CT or MRI scan and a PET scan?
The only difference is that the CT data is collected and it looks at what is physically in your brain and it makes slices. The PET scan, you give something which goes somewhere because of how the body's functioning, and that's what you're looking at. The example I give is that a CT scan or an X-ray tells you that the coffee is in the coffee cup. The PET scan tells you whether it's hot enough to drink.
Now, can you have a ballpark figure of how many PET scans you've reviewed over your career?
I don't know.
Thousands?
Thousands.
Okay. Now, you had a chance to sit in on Dr. Wu's testimony, is that correct?
Yes, I did.
And you also had an opportunity to review copies of a PET scan that was conducted or performed on the defendant, Luis Toledo, in this particular case. Is that correct?
Yes, I did.
All right. Can you tell us, within a reasonable degree of medical certainty, were you able to reach a conclusion after reviewing those PET scans?
Yes.
And what was your conclusion, Doctor?
I thought the PET scan was absolutely normal.
Okay. And Dr. Wu had a different conclusion, is that correct?
Yes.
And you disagree with that conclusion?
Yes.
Can you explain why you disagree with his conclusion?
Yes. The first aspect of what we do is, as Dr. Wu said, is look at the scan visually. And we have a set system. Is it a good quality? What's the global level of metabolism? What is the focal regional metabolism? And so forth. I went through that every single slice, and it's normal. The next thing is that some people, for various things, can use semi-quantitative analysis. Dr. Wu, I don't think he explained specifically what his analysis was and how he got there. There are a couple of programs that have been approved by the FDA that can be used as a clinical aid to visual diagnosis. They have been approved primarily to do Alzheimer's disease. And again, they've been established and approved by the FDA. And we do that sometimes when our visual says, you know, I'm not 100% certain, I'd like to get just a little bit more, and that's what we use them for. You can use these also in research programs. And there's a large project going on now funded by the federal government called the Human Connectome Project, because, as you can imagine, somebody like Dr. Wu develops a semi-quantitative program in his laboratory, and I believe the one he uses was done 20, 25 years ago with Dr. Buxbaum, but they use that, but nobody agrees with how rigorous it is, where in the program you choose one area versus another, and that's great for individual research, but if you're going to try to make sense of what they're doing in many laboratories, you ought to have a standard as best you can. And the federal government is in the midst of doing that, led by the University of Minnesota and Washington U and St. Louis. And again, Dr. Wu implied, I think, that two experts could look at a scan and come to a different conclusion. That in some ways is true, but in some ways it's not, because the two experts ought to be able to look and say, I absolutely see something and we're sure it's there, and then do you know enough to say, yes, this is an established pattern and I can do this and that. And again, he also implied that nobody could potentially disagree with numbers. And we all know there's, what do they say, lies, damn lies, and statistics. Well, numbers have to depend on what you use them for and how you get them. So creating a normal database is critical. And there's lots of databases out there, and as you can imagine, the one I mentioned that was approved for use with Alzheimer's was used and developed by people who had Alzheimer's, who were imaged over many, many years, and then unfortunately they did autopsies, so they have, because they die, they had autopsy evidence, and that's how you establish something that can be used from one lab to another.
Is PET scans, the use that Dr. Wu put them to in this particular case, is that generally accepted in the scientific community?
Let me phrase it this way. For research, PET scans are used all the time for any question you can imagine. And when it comes to brain injury, because of soldiers, because of young people killed in accidents and so forth, everyone is anxious to figure out how the brain works and how diseases can be recognized early. So it's used for research all the time. PET is a great tool, but in the area of neuropsychiatric and neuropsychological problems, it's still deeply in the research area. That's why Medicare and other insurance companies won't pay for it, because it's not established. And the worst thing you can do when you start doing something on 10 or 15 patients in your lab is to say, oh, that person has this, when in reality it could be a simple normal variation. And simple.
So if I understand you correctly, and if I'm not summarizing this correctly, let me know. The general scientific community, I mean, to reach the conclusions that he has made, because of all of the variables that may explain some of the things that he's talked to us about today, those are not reliable, and that's why FDA won't fund this type of work.
Well, they won't pay for it in an individual patient. That's why I say in research, you want to do these things and see what develops. But for instance, in order to use a test, you have to know how many normal people have this finding. You have to, in the area of the brain we're talking about, for example, he used a very wonderful example of the great case where, not if you're the patient, but a great case where the guy had the spike go in the front of his head. I mean, that's a big spike and a big area of brain that's abnormal. He used the Vietnam brain study. Those patients all had penetrating areas of the brain. You could see where a big lesion was, and there's no question, and I think most people agree, that the frontal lobe has something to do with personality and so forth. But what does it mean if you see a teeny area, because the brain areas do multiple things, and if you see something very tiny, one, is it real versus a normal variation? Is it there because the database wasn't accurate and reflected the specific population? And even if you find the anatomic abnormality, how it affects what you do is still under very active research. We can show, to the limits of our resolution, certain minimal changes, but we don't know what they mean at all. The example people use in our field all the time is somebody has a stroke and suddenly they can't write with their right hand anymore. Well, and they've got dead brain, they learn to write with their left hand. They learn to walk again because the brain is very adaptable. So you don't really know how an area of potential anatomic or physiologic abnormality, if we can learn to find it, affects the rest of the game. So they're going to be doing this research for a long time.
Is everybody's brain, does it look the same?
Generally, our brains look the same. There are two hemispheres, and they have frontal, parietal, so forth. But that's part of the problem in creating a normal database. If you look at all of us, we have different size heads. So if you want to create a normal, what do? Well, you take some size in the middle, and those of us who have a little bigger head, we got to cram that into that. And if your head's a little smaller, you got to figure out a way to expand it. And all of that manipulation creates uncertainty. And that's why a specific number is very difficult to use.
Is there something to be said, can two people's brain appear somewhat different but yet be within the range of normal?
Oh, sure.
Can you explain that?
Well, somebody's got a size 7 foot and somebody's got a size 9 and size 11, and that's generally all within normal limits. And if you find one that's a slightly different size, you still don't know whether that person can run fast or slow, or has stamina, or can use that foot to jump. So the anatomy finding, there's a wide range of normal.
Okay, and the variations you might see in a PET scan could also be within the range of normal, correct?
Yes, and the other item is the areas you pick to look at, specifically when you do numbers. The brain, if you've seen a picture, looks like it's got little hills and valleys in between. I didn't bring a picture, I'm sorry. But if you look at it, there'll be more activity in the hills, of course, because there's brain tissue, And in the valleys, there won't be as much activity. So now you do a slice, and the slice has hill, valley, and if you happen to pick part hill and part valley and pick the wrong place, you're going to get a wrong number. And again, that's why they're trying to develop these standards to use. Again, research is research. You can't do this in a clinical patient.
Now, we saw Dr. Wu's, his PowerPoint presentation, and he had sort of photographs of the brain, the slides of the PET scans that he was sort of analyzing, and we saw them sort of in these colors. Is that the way doctors who practice in this field, is that generally the way they look at PET scans?
No, the majority, overwhelming majority, look at them in a linear grayscale. You can use color to emphasize something. You're going to put something in a textbook, or you want to show a jury something. And we do that for a reason. I can explain it if you want.
Yes, please.
Okay. If you look at everybody in this courtroom, you're going to find people from 120 to 130 to 50 to 70 to 180 pounds. If you have a linear grayscale, the person who weighs 150 is going to be right next to the person who weighs 151, and there's no real difference in that. If you have a scale that, like, for instance, has 141 to 150, and next to it is 151 to 160, the people who are right at the edges of this will be two different colors. And your eye will say, oh, look, two colors, there's a difference. Been a lot of research in visual color stuff, and that doesn't mean anything. Now, it's possible the person at this end and this end will have two different colors, and they could be 20 apart. But again, you can emphasize the wrong things, and that's why you do a linear grayscale as your initial evaluation.
Okay. So if I understand you correctly, the use of colors in a PET scan to show a PET scan result can exaggerate subtle differences. Is that correct?
It can exaggerate subtle differences, and that's why we don't use it. And you can see that depending on the color scale, the images he showed look a little blurry, kind of. And I think you may have had some trouble seeing some of that when they pointed it out. They looked a little smooth, and the color tends to sometimes do that.
We also saw some of the black dots that he indicated were signs of that he found of abnormalities. What is your response to that?
Well, the program he used showed that those couple of areas were a little different than another area. And that's why the program made them black. But there's two or three things. The first is there are too many normal programs out there, and there's variation, and what does a little difference between 2.5 and 2.6 mean? So that's number one. Number two, again, when I said statistics, the bell-shaped curve says that if you're 2 standard deviations above the mean, it includes 67% of people, and if you go 2.5, you get 97% of the people. There's still the other 3%. If you're doing a study and using this kind of program, you don't really use those kinds of statistics because you're not asking a specific question. You're not asking, is there something the matter with the frontal region or what? He does that study, and his report indicates brain abnormality. Well, if you do that, there's a Frenchman, and his name is Bernoulli, his statistics say that when you use that kind of analysis, rather than trying to answer a specific question, but looking in general, the standard deviation values change significantly, and you have to get up to 3 or more before you can say something is worrisome.
Okay.
And again, I don't like to use the word specifically an abnormality, because in these circumstances, we're looking at variations of metabolism.
Now, and again, going back to those slides, we've already talked about how clinicians in the field do not use the rainbow scale, the colored scale. You talked about the grayscale. Are you going to see those black dots if you're looking at this in grayscale?
The black dots are something that is put on there by the program to say that the region of interest that I was looking at has a certain standard deviation. The program could put black dots or colors or anything, and if you're looking at a grayscale image, it'll put an area of black or green or whatever you want it to.
Okay. And that's the person who's conducting the analysis. He plugs whatever it is he's looking for in, and it will produce that result. Is that right?
Well, you run the program, but somebody writes the program, and it'll run. Doesn't matter who runs it. Let me just mention one other thing. Dr. Wu mentioned that he chose some place to measure. Let me just leave it at that. There's a lot of complications in how you use these kinds of statistical programs.
The bottom line is that this is reaching the conclusions that he is reaching in this particular case is not, while there may be research going on in this field, it has not been validated enough to be able to call these kind of conclusions reliable. Is that correct?
Well, that's correct. You don't know what to do with something you find, and if you don't know what to do with it, you can't use it. You can't read the history into the image. You get paid to do the image because it provides independent data. So you see something, we teach our residents, and we all make observations, then you synthesize your observations, and you come up with a differential diagnosis. And that differential diagnosis is based on your image. And we just don't know enough.
Anything that you saw in your review of these PET scans indicate that the defendant would have any kind of loss of impulse control?
The answer is no, because the study was normal. But it's my contention that you don't use these studies for that purpose, because it's not been validated. So no matter what you see, you shouldn't use it. I mean, if it was part of a research project, and people are doing it, they are getting prisoners, they're getting people on death row to volunteer for studies, and they're getting football players with this chronic traumatic encephalopathy. You can't diagnose that on a scan. But now they're trying to do images over time in all of these patients. They'll see which football player becomes more violent, which one dies of traumatic encephalopathy, and then you'll be able to go back and hopefully do a scan when a kid wants to play football in college, and do it at his first year and every year thereafter. Say, you know, your brain's taking a lot of hits, you better stop playing. We're not there yet.
You have a moment, Your Honor.
Thank you. Cross-examination? Yes, sir.
Your Honor, jury's in the presence of the court, see the
Thank you so much. Everyone be seated. Cross-examination, Mr. Nielsen.
Good afternoon, sir.
Good afternoon.
I have some follow-up questions to your testimony. Now, you talked about the use of PET scans for different areas that didn't sound to me like you had much of a problem with. For example, tumors or cardiology areas for scans and stuff. You said that's acceptable in your mind?
Yeah, I mean, it's not just my mind, it's the community, et cetera, et cetera. There are some tumors that it's not as good for, but in general, oncology is the major area of using PET scans today.
Okay, and you said it was good at detecting differences between scars and actual tumors and things like that, correct?
Yes?
And in Alzheimer's patients, trying to find or looking for the source of where the seizures are coming from? I mean, where the Alzheimer's is coming from?
Alzheimer's, yeah, you're looking for patterns that have been established based on, again, the autopsy results that have shown where these amyloid plaques get deposited and which parts of the brain are involved, and then you divine it.
All right, now you said that your business is, your work life is not just dedicated to working involving PET scans. You said that you do some consulting for drug companies. Is that correct?
Yeah, most of the consulting I do with drug companies deals with imaging, whether it's they're developing research protocols to submit to the FDA or for approval of a trial. I have developed atlases when a new product and new technique comes along, how to teach people how to interpret it.
So, sounds like you wear multiple hats out there in the business community. Is that fair to say?
Well, I'd rather call it the medical community because everything I do is based on imaging.
Okay. All right, fair enough, sir. Now, you did talk a little bit about the development or the evolution of these type of medical instruments. And let me ask you this, if Mr. Toledo is 36 now, and he was 10 or 9 when he first started having these seizures 26, 27 years ago, these PET scans machines were not very common, is that correct?
That's correct.
And so if back in the day, when Mr. Toledo would have been in the hospital for some type of head injury or seizure or something to that effect, it would not have been normal practice to refer him to a PET scan. Would that be fair to say?
That's correct. There are other imaging that was available, but the PET scan was not commonly used 26 or so years ago.
All right. Now, you've told us that in your opinion, you've seen the scans from the imaging center, the opposite of Dr. Wu's conclusion where he said they're abnormal. You said under record that your opinion is they are, quote, normal, correct?
That's correct.
All right. And would you agree that just like all of us, you are human and subject in your own world and even with your experience to be incorrect? Is that a fair statement?
I used to be perfect. I'm not perfect anymore.
Touché. All right. And I think you indicated that the database of the, quote, normal brains and stuff that you're aware that Dr. Wu was using or uses is, in your opinion, older, but you do agree it is accepted and used in practice still today, correct?
As far as I know, it's not sold anywhere, not approved by the FDA. In his report, he didn't say what program he used. He only showed two isolated regions rather than a full printout. And sometimes on those full printout, it'll say by CenterMed, that's one of them that's approved. So I shouldn't have said, I just don't know what he used, but from some past interaction with Dr. Wu and reading about what he has done, all his publications, I think he's using this database that was developed a while ago in California.
Okay. And you know, in addition to the, you described that visual analysis, there's also some new modern software that's utilized in the analysis too, correct?
For certain specific things with certain limitations, yes.
Okay. And you believe then that you indicated you disagreed with those darkened, the blackened images produced by the computer software. Is it your opinion also that the company that developed and uses that computer software is wrong or incorrect with what they're putting out there to the medical community?
No, let me just say this. Again, I don't know the software that your company that you're referring to, so I don't know their reputation as I do others. What I was saying is there are some black dots which on the image that he showed said that it was 2.5, I don't remember the specific, and I said, in my mind, I don't know specifically the region that was chosen, the region of interest that he used, as opposed to a voxel-based analysis. And as a result, the significance of that is very dependent on the software program used, etc. And it's okay in a potential research project where you're looking at groups, but you can't apply it to an individual patient. Not enough research, not approved, etc.
In your opinion?
Yes.
And you do seem, though, to be consistent in the fact that on some uses of this machine, it's fine and acceptable, but just not the way it was used in this case.
Well, everyone knows that. A Volkswagen is a great little car, but you're not going to run it in the Indianapolis 500 or the Daytona 500. I mean, a PET scanner is a great tool.
All right. You said that it's used even as recently as what you hear for sports fans out there about these ex-players and their concussion studies. It's used in that field, Alzheimer's and other fields.
Again, in Alzheimer's, the development of the use of PET scanners in Alzheimer's was in the U.S. by UCLA. There were several centers, one in Germany, one in the Netherlands, in which they followed patients for years. They did PET scans every year for up to 10 years. Then they did autopsies. After they did that, then they could go back, look at the scans, try to figure out a program to create a normal database using those patients as the Alzheimer's patients, and then tried to get a normal database. And as you can imagine, that's why they're trying to standardize it. Every database is different. Let's say I think I'm normal. I think you're normal. You may have some quirks. I have some quirks. So we're all a little different, and that goes into a normal database, if you will, but it's still dependent on the kind of people that are in the database. Okay. So that's why I'm saying research in a single laboratory, fine, but across the spectrum and in a clinical patient, and this patient may be forensic, but he's a human being, and you can't use it for that.
Okay, so these doctors and experts that are around the country working on these bigger cases like this NFL lawsuit and stuff, they're just going down a rabbit hole, they're wasting their time.
Again, the use of the PET scan in football players is research in progress. The people who are doing PET scans, if there are, I'm not familiar with a specific court case that's using a PET scan, But what I would tell them, as I've told you, you cannot use this to make a diagnosis because there are no established patterns, there no sensitivity or specificity. You can't use it. Now, you can use it and show color pictures for whatever reason you want to.
All right, well, that segues right into what I was going to ask you. You talked about this gray scheme, and in your opinion, you said that's the better way to go, right?
Yes.
All right, are you aware that Dr. Wu, in addition to the color scans, also does a visual with the grayscale? Do you know that?
Well, if you tell me he does, I will believe that.
Okay. And would you agree, sir, that a certain way you can do it with the grayscale? We've seen the color, but for courtroom presentations, would you agree that the color is better suited to explain perhaps to lay people what's going on with these images? Do you agree with that?
No.
Okay. All right. Did you measure and quantify any of the areas of damage that Dr. Wu has identified on the brain scans of Louis Toledo's brain?
No, I just received the brain scan this morning to look at it. I had seen his pictures a little earlier.
Okay. Did you take Louis's known scan and yourself compare it to any of these normal databases that you were talking about?
No.
Are you aware, sir, you talked a couple different areas about what you believe to be the still developing science, and perhaps this scan is not as widely acceptable. Are you aware that many textbooks do accept the science of brain injury being detected from PET scans? And are you familiar, and have you read Tchaikovsky's book on this subject, Cerebral PET SPECT Imaging?
Yes.
Right. You know there's a third edition of that book at this point?
Yes.
And you are aware, sir, that there is a large section of that book dedicated to what the author says is the usefulness in clinical and research acceptance of PET scans and brain injury.
Notice you said clinical and research, and I will continue to tell you that when you read every article in the literature, they all say may be helpful, more work needs to be done, larger groups need to be evaluated to determine its efficacy in clinical and research applications.
Okay, well, that general definition and description you just read, that could be applied to many, many areas of medical practice that are used and accepted all over the country in hospitals and doctor offices today. They're still developing and getting better at things, aren't they, doctor?
You'd have to be specific.
All right.
As you know, Medicare does efficacy studies on new procedures. They will pay for a certain number, for example, and acquire data. And when I say a number, it's a big country. They may do 50,000 or 30,000. And then they say the results don't allow us to say this is efficacious.
All right, let me ask you this. Have you read Osborne's book, used by many emergency room physicians, that also discusses the clinical acceptance of PET scans?
No.
Would you agree with this, doctor, that if someone has brain damage, it would show up on a PET scan in the frontal lobe area as decreased metabolism? Do you agree with that?
I'm sorry. Would you repeat that question?
If someone has brain damage to the frontal lobe and they are on a PET and they get a PET scan, it will show damage to that frontal lobe area with a decrease in metabolism.
And how do you know they have damage?
I guess the guy had a spike drilled through his head, sir. I'm just
If you had a
asking.
spike drilled through your head, that's why we do PET CT scans, because we would see the area in the brain that either had an area where, like, you core out, if you're getting ready to plant a bulb or something, and you see a hole, there's no brain.
Non-convulsive seizure disorder?
Yes.
And someone who has a long history of seizures like Mr. Toledo, do you agree that he could be suffering from that disorder?
That's a clinical question which I don't feel competent to answer.
Do you agree that stress can set off or increase the seizure disorder that people have?
I'm not an expert in that.
Do you agree that the statistical analysis described by Dr. Wu is a more sensitive way to analyze a scan than a visual analysis?
I think it's potentially complementary, but again, we're talking about a research use. In a clinical sense, there are no data of sensitivity or specificity in the things that Dr. Wu presented.
All right, let me ask you this, sir. Did you ever meet or speak or talk to Mr. Toledo?
No.
I don't have any other questions, Your Honor.
I thank you. Any retract? I think you may the witness be excused. State? Yes. Defense? Yes. Yeah. Thank you so much, sir.
Thank you.
Let me step down. All right, folks, we're going to have to take, I know, through no fault of anyone. I'm pushing hard, so I'm messing up the schedule. No good deed goes unpunished. So we're going to have to take a short break. It'll be roughly about 15 minutes or maybe a little bit longer. Take them back there, yeah.
Yes, ma'am.
They knock? Ready? Okay, bring the jury in. I think you may be seated. Ladies and gentlemen, once again, this witness is being called out of order. It is a state witness that's been called. State, call your next witness.
State calls Dr. William Meadows.
William Meadows, please stand up, raise your right hand, and be sworn.
Yes, Your Honor. Yes, ma'am, I do.
Thank you. You may have a seat. Speak loud and clear so the jurors can hear what you have to say. Pull the microphone down. Thank you.
Yes, sir.
Thank you, Your Honor. Good afternoon.
Good afternoon, sir.
Could you introduce yourself to the jury?
Hello, my name is William Robert Meadows. I'm a consulting forensic psychologist.
All right. And how long have you been practicing in the field of forensic psychology?
About 24 years.
Okay. And can you just briefly give us an idea of your sort of educational background as it relates to the field?
Yes, sir. I received a Bachelor of Science in Psychology from the University of Florida, a Master's of Science and PhD from Florida State University in clinical psychology with specializations in forensics and addictions, and I completed a postdoctoral fellowship in forensic psychology at Harvard Medical School in Boston.
All right. And your work history, can you briefly describe that as well?
Yes, sir. I've worked in a variety of correctional facilities, conducting evaluation and treatment services, beginning in Massachusetts and then extending into Florida. I've worked at the Florida State Hospital Forensic Unit in Chattahoochee, conducting examinations and providing treatment services. I was the Director of Forensic Services at the Northeast Florida State Hospital in McClenny, say for about 8 years before going to full-time private practice as a consulting forensic psychology, where I conduct examinations at the request of the public defender's office, private attorneys, state attorney's office, and through court appointments.
Okay, so you've conducted evaluations not just for the state, but you've also done evaluations and have testified on behalf of defendants, defense attorneys, as well as after being appointed by the court. Is that correct?
Yes, sir.
How long have you practiced in this field?
Beginning in grad school, my first practicum at the state hospital in Chattahoochee in the forensic unit was in 1990.
Okay. So it was about 27 years?
Yes, sir.
Okay. I was worried my math was wrong there. Tell us, have you ever testified in court in the field of forensic psychology?
Yes, sir.
And you have any approximation of how many times?
I don't know exactly, well over 100 times.
All right. You were asked to conduct an evaluation in this particular case regarding the defendant, Luis Toledo. Is that correct?
Yes, sir.
When was the first opportunity that you had to meet with him?
I met with him a few days ago, I believe it was Monday. I went to the jail to see him.
And were you able to conduct an evaluation at that time?
No, sir, he refused to meet with me at that time.
Okay. Since then, did you have another opportunity to do that?
Yes, sir.
And when was that?
That was last night,
All right. And how long did you meet with the defendant?
about 2 hours.
Now, before we kind of get into your evaluation, did you receive materials with regard to Mr. Toledo to review in advance of your evaluation?
Yes, sir.
Can you briefly describe some of the materials that you received?
I received a defense evaluation report by Dr. Mings, several other examination reports throughout the year's competency examination reports. Also received medical records from his incarceration periods.
Okay.
Also some deposition reports, things of that nature.
Okay. The records from his incarceration, are you referring to prison records, Department of Correction records?
Yes, sir.
All right. Now, and you had a chance to review all of that, is that correct?
Yes, sir.
Kind of what was the purpose of you in going into the evaluation, sort of what was your purpose in doing that?
We generally call it an aided disposition examination. Having been retained by the state, they were interested in me looking in particular at a defense psychological report that was being introduced as mitigation. And so as a consulting forensic psychologist, I would look at that to see if those conclusions are valid, if there are any problems in the assessment, and with my assessment coming up with my own conclusions.
And you were aware that that Dr. Mings had diagnosed the defendant with what he referred to as a minor neurocognitive disorder, unspecified bipolar disorder, and attention deficit hyperactivity disorder. Is that correct?
Yes, sir.
Okay. So when you went to meet with the defendant, so talk to us a little bit about when you met with him and then what you did upon meeting him.
I met with him and gathered psychosocial historical information related to his family background, educational history, employment history, psychiatric treatment history, criminal arrest, any alcohol or substance abuse, marital history, things of that nature. And then along those lines, evaluating his mental status to see if there are any active psychiatric or cognitive disturbances.
Okay.
That would be the background and the mental status part.
Okay. Now, did you conduct any psychological testing with regard to the defendant?
Yes, sir.
And what type of psychological testing did you do?
Psychological and personality functioning. The instrument also assesses the degree that an examinee may be exaggerating symptoms on the test or minimizing them.
And before I get into specifically the results of that, were you aware that Dr. Mings had conducted a number of tests himself?
Yes, sir.
Okay. And those tests, what was your understanding of the tests that he performed on the defendant when he met with him?
He conducted, he administered an intelligence test and also a memory test, and then administered one test of malingered memory.
Now, is it your understanding that with regard to the scores that he reported out on the IQ test, the Wechsler, the WACE-4, and I always get it wrong, but the WACE-4, that's an IQ test, is that correct?
Yes, sir. Wechsler Adult Intelligence Scale.
Thank you, sir. Was it your understanding that the scores that Dr. Mings reported out of the defendant were essentially average, is that correct?
Yes, sir. They were, his verbal score was lower than his nonverbal scores, but essentially he was functioning at the average range.
Were you aware that, that Dr. Mings had made some findings regarding the differences in his scores on the nonverbal reasoning of the test and his verbal reasoning?
Yes, sir.
All right. And he seemed to indicate that, and he indicated that that indicated some type of neurological disorder. Is that correct?
He did.
And do you agree with that assessment?
No, sir.
And can you explain to the jury why you don't?
Yes, sir. First off, it's not a neuropsychological assessment. He administered an intelligence test and a memory scale. Those are two components that are part of a battery of neuropsych tests that are administered by neuropsychologists. So, in my opinion, he's overreaching in providing a diagnosis of which he termed as minor neurocognitive disorder. Along the lines, there is no such diagnosis in the DSM, which is the manual that psychiatrists and psychologists use. That's not appropriate nomenclature. There's mild neurocognitive disorder, but I'm not sure if that's what he means when he says minor. The most commonly used neuropsych batteries in the United States are the Halsted-Raytan battery, which includes a number of different measures. I won't go into it to burden the jury unless you ask me to, but they're well beyond what he administered. And then also a second battery would be the Loria, Nebraska battery, which neuropsychologists typically administered. So it's inappropriate to provide that type of conclusion when one doesn't administer what's recognized as a standard neuropsych test battery.
Okay. Now, yesterday, I believe he, if I'm wrong, somebody I'm sure will correct me, and the folks can rely on their own memory, but yesterday, my memory is that he testified that he conducted a battery of neuropsychological testing on the defendant.
Well, again,
Is that correct
those
or
are
not?
two instruments that are often included into a battery of additional instruments. So that is not a recognized complete neuropsychological test battery. Again, the two most common one are the Halsted-Raytan, which includes other types of measures that assess for psychomotor problems, aphasia, different kind of things that these measures don't assess for. So these are two, this is an intelligence test, it's a memory test, it's included in neuropsych test batteries, but again, it falls short as far as being recognized as a neuropsych test battery.
So these would be two tests that you might include within a battery of neuropsychological tests, but you would not completely rely on these to reach a conclusion regarding the neuropsychological condition of a patient. Is that
It
correct?
falls well short. The results that were provided in these tests were significant in the sense of reaching some conclusions. Often in the practice of psychology, one may administer these tests, and if you see a certain pattern of results, then you may recommend a follow-up with a neuropsychologist or may administer something like the Halsted-Raytan to follow up on that. Typically, you'd want to see a different pattern of scores than what he reported to suggest that there is a neurocognitive problem.
All right. And that was, and is that the conclusion that he reached when he found that there was a significant difference between the defendant's nonverbal and verbal reasoning abilities?
That's part of it.
Now, do you have any particular, your own conclusions concerning those scores and the conclusions that he reached?
Yes, sir.
And what are those?
These scores are highly inconsistent with any type of neurocognitive disorder.
Can you explain that?
Yes, sir. In his report, he indicates that the lower verbal comprehension index suggests neurocognitive problems, and that's inaccurate. It is true that when there's a split between nonverbal and verbal scores, that may suggest neurocognitive problems that would require follow-up, but the difference is actually the reverse of what he reported. People with genuine neurocognitive problems typically have lower nonverbal IQ scores, not necessarily the verbal IQ scores. His lower verbal composite score is easily explained by his educational level. I mean, we're talking about somebody's vocabulary, somebody's verbal knowledge, somebody who has had problems in their academia. For example, people may be sent to alternative schools because of behavioral problems. They may be incarcerated because of behavioral problems. And so they don't get the full academic environment that's desirable for children. That typically explains lower verbal scores, not a neurocognitive problem. Neurocognitive problems would relate to somebody's visual spatial perception, their psychomotor speed. Those are directly tied to brain injuries and other types of impairment in the brain. So it's just erroneous to say that because he has a lower verbal score and higher nonverbal scores that indicates it's a neurocognitive problem. Again, usually you see the opposite, where the nonverbal scores are lower.
And in this particular case, his nonverbal reasoning abilities, as the scores reported out, were actually very high, were they not?
Well, and that gets to the second domain when I looked at these test results that show that they're totally inconsistent with a neurocognitive problem. In the DSM-5, which I have here, this is again what we are supposed to rely on in the United States. It says specifically that a mild, and we're talking about mild, not even a moderate or severe neurocognitive disorder, but a mild neurocognitive disorder, these nonverbal scores, their percentile rank should be falling somewhere between 3% and 16% for a mild neurocognitive disorder. Again, he classified as a minor, so I'm not sure what that means. But if you look at the actual percentile ranks of these nonverbal scores, he has listed the perceptual reasoning index, which should be very low if there's a neurocognitive problem, at 73%. Well, that's well above a 16% percentile rank, which the DSM indicates is associated with a mild neurocognitive disorder. He then shows that his working memory was at 50% percentile, which is well above a 16% percentile, which is necessary for that diagnosis, and then a 70% percentile for processing speed. Now, I can tell you, people with neurocognitive disorders such as dementias or brain injuries typically are impaired in their ability to process information at a normal pace. And a percentile of 70%, meaning that 70% of the general population, he would score higher than those individuals. That's again well above the 16% percentile that's typically seen, and that's the ceiling of the range. It's 3 to 16% that would be seen for that particular domain. So I didn't feel a need to re-administer the intelligence test because I think his test results speak for themselves in that they're highly inconsistent with a neurocognitive disorder.
Quite to the contrary, correct?
Yes, sir.
And you say that his I guess, relatively low scores on the verbal reasoning can be attributed to his lack of education. Is that correct?
Yes, sir. Verbal reasoning is the accumulated experiences that we've derived from our academic background as well as our cultural background. We don't learn everything in school. We learn things from our family, our grandparents, our neighbors, and so that's accounted for in that measure. So if somebody has a deprived learning environment, that they haven't been going to school, they've been kicked out of school, they've been sent to alternative schools, they've been incarcerated while going to school. Well, they haven't had the same opportunities, in large part because of their behaviors, but they haven't had the same learning environments. So one would expect that their verbal scores would be lower. Now, the nonverbal scores basically is a measure of their intellectual potential. That means if this person actually had normal academic backgrounds, then they should have been up a bit higher. It tells us, what can somebody actually learn and attain, and he's into the normal range. So neurocognitive disorder, there's no such thing as a minor neurocognitive disorder. This is a major form, psychiatric impairment. Now, there's different severities. There's a mild form, a moderate form, and a severe form. But in order to diagnose that, you can't just look at a PET scan or an MRI. You have to assess the person as far as their adaptive functioning. That is, are they having impairment in employment and other areas? And also their functional capacities as demonstrated in these types of instruments. And it's clear that on this intelligence test, he demonstrated well above what somebody with a neurocognitive disorder would show.
And setting aside the scores, assuming that there was some evidence of a neurocognitive disorder based on these scores, you talked a little bit about adaptive functioning. Is that also, and impairment, is that also part of the criteria that you consider before you actually diagnose somebody with, say, mild neurocognitive disorder?
Yes, sir.
And can you explain that when you met with the defendant, did you talk to him about aspects of his life that would give you some indication as to his adaptive functioning?
Yes, sir.
And can you kind of explain to the jury what you talked about and what your conclusions were?
Well, I asked him, for example, about his occupation, and he had indicated to me that he was working full-time at a credit bureau, was in a training program. I asked him if he had any kind of deficits related to his performance. He said no. He said it was working out well, and he anticipated that he would finish the program and be able to do that. While he was doing that, he was juggling participation in a vocational tech school for becoming a barber, and actually told me that he was the best student in that particular program. Said that he was able to engage in those kind of activities. People with neurocognitive disorders often have impairment in fine motor skills, and so that I'm not a barber, but I've certainly had my haircut. I can know that there's a requirement for people to be able to coordinate with their hands and be able to provide a haircut for an individual and being flexible cognitively and doing those kind of tasks. Somebody with a neurocognitive disorder, I think, would show difficulties in those kind of tasks. He indicated that he was able to pass tests. He did say that, times he had to repeat the test. That's not surprising given that lower verbal score, but he was able to pass those tests. So just based on his education and juggling that with his occupation, that's inconsistent with a neurocognitive disorder.
What about did you talk to him about his ability to handle money and things like that?
Yes, sir. He indicated that his wife tended to handle the financial affairs, but he said he did have the capacity to do that and was able to count G2. He's able to drive in the community, find where he's going. No reports of the types of memory problems that a person with a neurocognitive disorder would have. One must think of an individual who even is in the early stages of an Alzheimer's disease. Often they will get lost because it's difficult to manage a new environment, to put things together. Those are the kind of deficits that are typically seen. And the DSM, again, this manual gets into the nature of these deficits, and the report by Dr. Mings was that this person essentially has had these types of deficits and relates it to this case, but the DSM, the manual that provides for the diagnosis, is inconsistent with his diagnosis because the manual states that these type of deficits in mild neurocognitive disorders tend to be resolved. It's the ones that are involved with moderate and severe cases where you would likely to see the impulsivity and the aggression and the lack of ability to regulate affect. So again, that was another piece that I had trouble with in reading that report, in that it just doesn't fly with what we know about these types of disorders.
So if I understand your testimony correctly, even if someone has mild neurocognitive disorders, you would not expect them to have low impulse control. You would find that in the more severe forms. Is that correct?
That's exactly what the DSM gets into, particularly when we're talking about traumatic brain injuries, which is the inferences that have been made. It states, if you read the DSM, that after a brain injury, within the first year, you may see deficits, but then those tend to resolve. When they don't resolve, then you start thinking moderate to severe neurocognitive disorder, because then there's clear indications that there was a brain injury and it continues to impact the person. So I didn't see in my reading of the records, which I think, in particular, the state hospital reports findings were consistent, and that they specifically assessed him for neurocognitive problems over time at the state hospital. And they indicated that there was no indications that he was having the types of problems that people with these disorders have, such as memory impairment, inability to keep a schedule, cognitive inflexibility. None of that was noted by a multidisciplinary unit over time, which is typically a good assessment for these kinds of issues.
Was there a recommendation that that treatment team made with regard to further testing to determine, that was the same report that talked about him malingering, is that correct?
Yes, sir.
And was there any recommendation that they had made to explain why he was malingering?
I don't recall specifically recommendations. I recall them reporting their impression that he was malingering being either faking or exaggerating psychiatric or cognitive problems. Having been a director of a forensic program, I can tell you that is something that these clinicians do need to assess for, particularly in criminal cases, and typically the way they do that is through testing, but also through observation of an individual across different situations. Malingers can go into an examination and start reporting all kinds of symptoms. I mean, anybody can do that, but it's very difficult to maintain that 24/7 in a psychiatric hospital, and so it's a fairly comprehensive assessment.
And that wasn't the only report that you reviewed, correct? That gave some indication that in the past, when the defendant was in trouble criminally, and psychological tests were administered, that he was found to be malingering. Is that correct?
That's correct. I mean, there were several different competency reports, not just for this case, but for previous cases, and there were. There was a variability in diagnoses, but there were examiners that noted malingering.
Okay. Going back to that report from the North Florida Evaluation and Treatment Center, do you recall them recommending that personality testing be done with regard to the defendant?
I don't recall that recommendation specifically. I wouldn't be surprised by it, but...
Would that be something that I think when you referred to the Minnesota Multi-Phase Personality Inventory, that is a personality test, is that correct?
Yes, it's the most commonly used personality test and the one that has, in my opinion, the most empirical support. It's a very comprehensive measure, and so yes, I attempted to give it to him. I did give it to him, but due to exaggeration, what I mean by exaggeration is the MMPI has specific items that are unrealistic. It's to try to, I don't want to say catch people, but to see if people are approaching the test in an honest way. And some people, for certain motives, particularly in criminal cases, may over-endorse symptoms or trying to make themselves look ill when that's not actually true. There's also scales for individuals who are minimizing symptoms. I often see this in divorce cases. Everybody wants to look good in a divorce case when there's child custody issues. So many times MMPI cases and divorce cases it's a minimized profile. It's invalid because the person looked too good. It's like they had absolutely no faults whatsoever. So it assesses for that. When you see that somebody is over-exaggerating past a certain point, then the test is invalid because the person is just responding to items that don't make sense or trying to portray themselves as being ill when they're actually not.
And again, we'll get to that in just a few minutes. I want to ask you about Dr. Ming's conclusion that the defendant has bipolar disorder. Did you see that amongst his conclusions?
Yes, sir.
Okay. And did you see any evidence of that either? Well, let me just ask you just straight up. Do you diagnose the defendant with bipolar disorder?
No, sir. Okay.
And can you explain why not?
I didn't see sufficient evidence of symptoms to warrant that diagnosis. This individual currently is on an antidepressant medication. He's on a type of medications that would treat bipolar disorder. There hasn't been any reports of any recent manic episodes. He denied, when I assessed him in an open-ended way, what types of symptoms he's experienced. He didn't describe the types of manic symptoms associated with a bipolar disorder. He's had that diagnosis in the past, but he's had a number of different diagnoses that are inconsistent with that diagnosis. So because he wasn't on any antidepressant medications, wasn't on the types of medications for bipolar disorder, was only on an antidepressant, and was denying symptoms that would be necessary for that diagnosis, and just the observations, including those of the state hospital over time, that he wasn't presenting with symptoms of a bipolar disorder. I feel comfortable in stating, in my opinion, that he does not suffer from bipolar disorder.
Now, you received records from the Department of Corrections that indicated on a number of occasions that he was diagnosed by mental health professionals within the prison system with bipolar disorder. Is that right?
Yes, sir. Well, at times he was, and other times they didn't diagnose him with it. They diagnosed him with depressive disorder. So, when you look at the actual details of the symptoms that they describe irritability, depression, and having difficulty with officers, and that's not sufficient to diagnose somebody with bipolar disorder.
What about hallucinations, auditory, visual hallucinations? There were some indications that was reported. Is that correct?
By his report, he had indicated that he had hallucinations. I asked him about that. He says that he hasn't had any types of hallucinations since he was incarcerated early into his prison, and he says that he wasn't even sure if those were hallucinations. He said people told him that they were hallucinations. So, it's just surprising to me that somebody could go for so long without an antipsychotic medication or mood-stabilizing medication and not show those kinds of symptoms, and that typically rules out that diagnosis.
Okay, and we're talking about, as I understand, he got out of prison in 2007 until this incident, which occurred in 2013. And in your conversation with the defendant, he indicated to you, he didn't indicate anything to you that would indicate any symptoms of bipolar disorder within that period of time. Is that correct?
Correct.
And without medications, you would expect that there would be some symptoms that would be reported within that time frame if he was not on antipsychotic medications, right?
Yes, sir.
How do you explain the medical records from the Department of Corrections, which at times diagnoses him with bipolar disorder?
Well, I think he certainly had adjustment problems while incarcerated. And again, there's been inconsistencies in those diagnoses. So, a lot of times, in having worked in corrections, having done these diagnoses and worked clinically with inmates, you're going on their self-report. And so I don't feel comfortable with that diagnosis, given what I observed in my examination. I would offer diagnosis of something like persisting depressive disorder, which is consistent with other diagnoses he's received before, consistent with the observations at the state hospital over time, and also the current medication that he's on. But I don't, in my opinion, I don't think a diagnosis of bipolar disorder is warranted.
Can drug use manifest itself with the same type of symptoms as you would sometimes see with bipolar disorder?
Yes, sir, it can, particularly hallucinogens and amphetamines. Amphetamines can cause a person to be accelerated in behavior, can have them talking quickly, can have them acting impulsively, and hallucinogens can lead to psychotic processes, hearing things, seeing things.
Was there any indication either in your review of the Department of Correctional records or in your interview with the defendant that he was using those types of drugs while he was in prison?
I recall notations of him having problems with LSD and amphetamines. When I had talked to him, he completely denied ever using these substances, but there were multiple notations in the medical records of him having those problems.
And if I recall you just saying just a few minutes ago that a lot of times these diagnoses are essentially based on the inmate's self-report of symptoms. Is that correct?
Yes, sir, particularly when involved in clinical cases, not necessarily in forensic cases. In clinical cases, the clinician is motivated to treat the person, not necessarily motivated to look over their life, to try to understand why somebody's reporting these symptoms. And so as a clinician, you go, it's kind of like going to your doctor. You tell them you have these types of symptoms, and they may prescribe a general antibiotic. That's very similar to what the psychiatrists do, is they see the individual who's reporting these kind of symptoms, and then they prescribe a medication.
Is there having worked in forensic psychology, is there with regard to defendants, either while they're going through the criminal justice process or while they're incarcerated, is there a high motivation on the part of defendants to malinger symptoms of mental illness?
It varies by person, but it's certainly an incentive. The DSM and other authoritative texts in psychology related to malingering, one of the first factors you got to look at to see if the person may be malingering is are they involved in a criminal case. And so not every criminal defendant malingers, but a significant number do, because there's many times an incentive in insanity cases is to try to be found not guilty but due to insanity, and in incompetency cases they may malinger being incompetent, because often it's common knowledge that after 5 years of incompetency the state's compelled to dismiss cases. And then in aid to disposition or sentencing hearings, often the people that are malingering are doing that to gain some sort of sympathy from the court.
Okay. And there was a lot of evidence in this particular case, was there not, from other psychologists that during that time frame, the defendant was found, in their opinion, to be malingering mental health symptoms, correct?
I don't know if I classify as a lot, but there was significant evidence. I mean, there were multiple clinicians that came to that conclusion. I know in my examination, the MMPI is not a malingering measure per se. It includes symptoms that are current and historical in nature. Malingering measures hit on current symptoms, and he wasn't, in the mental status component of my examination, wasn't endorsing current symptoms. So I didn't administer a specific malingering measure. The problem with his findings in the MMPI is that it gets into historical features, and the MMPI was consistent with a pattern of malingering in that, again, he just over-endorsed so many symptoms on the test that he essentially invalidated it.
So in trying to administer the MMPI test, what was sort of your goal or your purpose in administering that to him?
The MMPI test, I was giving it to him because one is the number of inferences that were made by the defense expert. Essentially, when I read that report, I mean, I was just taken aback by the fact that it wasn't a true neuropsych test battery. Secondly, I looked at the actual test results from the tests that were administered that are part of a battery, and those test results were inconsistent with the conclusions that were being stated. Had I administered those tests and got those same results, I wouldn't have even gone down that track, because they're just so inconsistent. I wouldn't have referred him to a neuropsychologist if I was consulting for defense, but there may be other types of mitigators, but that's not one of them. So there were inferences made that this individual has this minor neurocognitive disorder that somehow is related to this case. I looked at this person's history, and I saw a number of antisocial features related to his history dating back to childhood. And he's had diagnoses of antisocial personality disorder.
Can I stop you right there, Dr.
Yes, sir.
Meadows? When we talk about mental health disorders, how would you characterize antisocial personality disorder with, say, something like bipolar disorder?
Antisocial personality disorder is not considered a form of mental illness per se. It's not a defect in the brain. It's often related to a pattern of upbringing. There do seem to be some hereditary factors, but essentially a personality disorder are the types of personality traits that get people into trouble. And they're exaggerated personality traits. And a mental illness, a personality disorder can't be treated in the same way that a bipolar disorder is with medication. That's, where medications treat the imbalance of neurotransmitters in the brain for a bipolar condition. It's not the same thing for an antisocial personality disorder. Now, an antisocial personality might give some medications that help calm them down, but it's basically a personality that has just gotten out of control, and the way the person perceives the world, reacts to other people, has feelings or a lack of feelings. That distinguishes the personality disorder.
So in other words, instead of it being a mental illness per se, it's a character defect. Is that correct?
That would be a good way to put it, yes, sir.
And you said that that the records that you received were replete with diagnoses of diagnosing the defendant with antisocial personality disorder. Is that correct?
Yes, sir. There are multiple evaluators that had provided diagnoses of antisocial personality disorder. And then going back to your question about the MMPI, that was one of the reasons for administering it, is because rather than this being a neurocognitive disorder as an explanation for these offenses, an antisocial personality disorder, in my opinion, is a better explanation. Now, I had evidence of that diagnosis from his records. The MMPI is a test that can assess for antisocial personality disorder as part of a comprehensive assessment. And so that was one of the reasons why I administered it.
And just to talk just a little bit further about antisocial personality disorder, yesterday Dr. Mings testified that while he did not necessarily disagree with that diagnosis, he did not see enough evidence in the record or the records that he received, which requires, in order to diagnose somebody with antisocial personality disorder, that there had to be some evidence of a conduct disorder in that person prior to the age of 15. Did you, in your review of the records, did you see evidence that would meet that criteria?
Well, there was evidence of behavioral problems in childhood that had been discussed in the records, but also in my assessment and clinical interview of him, he described the types of childhood problems associated with a conduct disorder that typically are precursors to antisocial personality disorder. He talked about being charged at age 14 with grand theft auto. Most juveniles aren't charged with that kind of crime. Well, that is commonly seen in cases of antisocial personality disorder.
Yes, sir. The jury will disregard the witness's last answer as far as juvenile record. You may proceed.
And not to get any specifics of that, Dr. Meadows, the bottom line is that there was evidence of a conduct disorder with regard to the defendant prior to the age of 15. Is that correct?
Yes, sir. His own report confirmed that.
All right. And in your opinion, did he meet all the other criteria for a diagnosis of antisocial personality disorder?
Yes, sir.
Now, I want to talk to you now about your administration of the MMPI, the Minnesota Multi-Phase Personality Inventory. You said that the reason that you conducted that test was to follow up on any sort of personality disorders that he might have. Is that correct?
Personality, but also psychiatric. The MMPI also gives an indication of bipolar disorder. So it's a comprehensive assessment, and so it wasn't just personality disorders.
Okay. So this test can actually give you some indication as to whether or not he actually does suffer from bipolar disorder.
Yes, sir.
And can you kind of describe the test? How is it administered? How long does it take? And so on and so forth.
The length of time varies by person. Usually, intelligence may be a factor. Some people just are more kind of obsessive compulsive in taking tests and things like that. So it varies by individual. It's 567 items, true, false. It's not even questions, it's statements. I can't give you an actual statement because that would be violating the copyright, and there's just concerns about that. But an example might be, I like to drive a car fast, true or false. And it's a forced choice test, meaning that you instruct the person that you have to respond either true or false. You can't respond true and false, and you can't skip any items. So some people might feel like it might be true, might be kind of true, might be kind of false. They have to pick one, true or false. And then their pattern of scores goes into different scales that give indications of what kind of symptoms they may be having, such as bipolar disorder or psychotic disorders or depression, and also personality disorders, such as antisocial personality disorder. Now, embedded within those items are validity scales. And the validity scales, again, look at items that are not really related to true mental illness, and essentially the more that you endorse those, the more exaggerating you are of your psychiatric symptoms. And then there are other ones that relate to minimizing problems, and these are unrealistic characteristics of people. I can't give you an exact item, but let's say, I never sweat, true or false. Well, everybody sweats. So somebody who's trying to be over-virtuous may respond true to that. And if they hit too much of that, then they invalidate the test because they're not being realistic.
And how long did it take the defendant to complete this testing?
I want to say maybe 45 minutes.
And what were the results?
Again, he invalidated the test, the F scale and the FB scales, which are the ones that relate to exaggeration of symptoms, are well above the cutoff score. And so there really isn't anything that you can say other than he didn't approach the test honestly.
So the test results were invalid.
Yes, sir.
And the indication is that he was malingering, is that correct?
It's consistent with malingering, yes, sir. Again, I didn't administer a malingering test because he wasn't endorsing current symptoms. The test tapped into historic symptoms. So it was consistent with him malingering historically symptoms.
Okay. And so you were not able to get any kind of results from that, is that right?
Well, the result was he wasn't honest when administered a test. And his tendency was to exaggerate problems.
So as I understand, Dr. Meadows, your conclusions in this particular case is that the defendant does not suffer from a minor or mild neurocognitive disorder, is that correct?
Yes, sir.
And your conclusions is that the defendant does not suffer from bipolar disorder, is that right?
Correct.
And that he does suffer from antisocial personality disorder, is that right?
Yes, sir. I would add, I think a diagnosis of persisting depressive disorder would be appropriate. Diagnoses don't get into the origins or causes of disorder. Somebody could be depressed because of their situation. They've been incarcerated a long time or other kinds of stressors. It doesn't necessarily mean there's something chemically wrong with the person. It doesn't imply that.
Thank you. No further questions, Your Honor.
Okay, cross-examination.
Thank you, Judge Lombrano. Good afternoon, sir.
Hello, sir.
So let me make sure I understand this testimony. Dr. Mings is wrong and you're right. Is that correct?
I mean, if you want to characterize it, I stated specifically as far as the test and the results that I see as being inconsistent with conclusions. I think you could reference the DSM very easily and see that to be true.
All right. Dr. Mings testified he had 30-plus years in the field. Administered over 10,000 times, these neuropsychological tests. Are you aware of that?
No, sir.
And if you are made aware of that, so 10,000 times Dr. Mings is wrong. Is that your testimony?
Well, I didn't state that.
Okay. He's testified in courtrooms across the state hundreds and hundreds of times. Was he wrong each time?
Sustained.
You said that the bipolar disorder, you didn't find it, correct?
I don't see that being an appropriate diagnosis.
All right, but you do agree that it was throughout all the historical records that you reviewed. Is that true?
There was inconsistencies in diagnoses. Sometimes he was diagnosed with bipolar disorder, sometimes he was diagnosed with depressive disorder in the same institution.
Isn't it true, sir, that throughout the records that you reviewed, bipolar is one of the diagnoses that's repeated on multiple occasions?
One of several, yes, sir.
All right, and would you agree then that all the doctors and all the prisons, or the prison over the years, they're also all wrong in their diagnosis of Mr. Toledo? Is that correct?
I don't agree with the diagnosis of bipolar disorder.
Okay, so those other doctors, they're all incorrect. Is that correct? Is that your testimony?
Again, I don't agree with that diagnosis. He had, in the same facility with the same, assuming the same clinicians, at one point he's diagnosed with bipolar, another time he's diagnosed with depressive disorder.
All right. So you're not comfortable with bipolar. You met with Mr. Toledo for one time for 2 hours, correct?
Yes, sir.
He was in that prison setting for years where all those other diagnoses came from. Do you agree with that?
He was also at the state hospital for quite a bit of time where he did not receive that diagnosis
Yes,
with
sir.
individuals who are there specifically to observe him and his behaviors related to psychiatric illness. So if one were to look at that, I think that is significant.
All right. You say he didn't do well on the MMPI, correct?
It's not a matter of doing well or not well. He presented a certain way.
All right. You know that me and Mr. Nappy were there last night, right?
Yes, sir.
And you're saying that he didn't sit down and try to do that test. Is that your testimony?
That's not what I said.
Okay. Let me ask you some other questions, Doctor. You said that during this examination last night of Mr. Toledo, you covered a number of different topics, correct?
Yes, sir.
All right, let me ask you about some of that. You talked to him about his school years, right?
Correct.
He told you he dropped out in the 9th grade, correct?
Yes, sir.
All right. He said later on when he was in prison, he was able to get an equivalency diploma for high school. Is that accurate?
Yes, sir.
You talked to him about his father last night, didn't you?
Yes, sir.
Did he tell you his father was deceased?
Yes, sir.
Did he tell you how old he was when he died?
I don't believe so.
Did Lewis tell you that when his father was ill and dying, that he himself took care of his father when he was ill? Did he tell you that?
I don't recall him saying. I know he indicated that his father had passed away
Can you look
at the
your
time that
notes?
I'm looking at him right now.
You don't have a note that said he himself took the responsibility of taking care of his ill father. You didn't write that down?
I don't know that that's what was stated.
Did you discuss his prior incarceration case with him?
Yes, sir.
Did he tell you that when that happened, he was 17 years old?
Which one?
The case that he landed in prison for. You did the math last night, you remember?
Yeah, there were multiple cases.
Okay, I'm talking about the time when he was in prison in 2003 to 2007. When that event occurred, he was 17 years old. Is that correct?
Yes, when he went to prison, the charge occurred at 17, and then he said he went to prison when he was 20.
Correct. Did you discuss with Mr. Toledo last night his history of psychiatric hospitalizations?
Yes, sir.
And did you find out that he had been in one as early as 9 years old for roughly a 7-month inpatient treatment? Do you remember that, sir?
Yes, sir. He said that he reported that he went to Mount Sinai for 7 months when he was a juvenile.
As a 9-year-old little boy, he's in a mental hospital for 7 months. That's your understanding, correct?
He reported again as a juvenile he was at the hospital for 7 months.
You have any evidence to say that's not true?
No, I don't dispute it. I'm going by what he said.
You discussed with Mr. Toledo in general terms his mental illness, isn't that correct?
I don't know what you mean by general terms. I asked.
Okay, well, let me see if this is fair. You asked him if he had any mental health problems, and he said yes. And you said what? And he indicated that he got irritated easy, he suffered from mood swings and things of that nature. Do you recall that?
I recall that being the entry point of discussion, and when he said mood swings, I asked him to elaborate and to describe exactly what those mood swings were.
Did you ask him questions last night about his mother?
I asked him who he was raised by, and then in discussing his family history, it indicated his mother was also deceased.
Correct. And did he also tell you that she had passed away while he was in prison?
Yes, sir.
Did he also tell you that that affected him in a very negative way, and he was extremely distraught about her death while he was in prison and getting ready to be released back to society?
No, I think those are your words. He described that as being something contributing to his depression.
All right. Did he tell you that he was so upset by the loss of his mother while he was in prison, he tattooed an image of his daughter on his arm? You remember that?
When he talked about tattooing the image of his daughter, he said that he talked about some self-injurious acts while he was in prison, and so he related the tattooing of his daughter to that. I don't believe he related to his mother.
Did you ask him about his medical issues last night?
Yes, sir.
Did he tell you he suffered from high blood pressure?
Yes, sir.
Did he tell you he had early signs of ALS or Lou Gehrig's disease?
Well, he told me that a doctor had come in and told him that he had early stages of ALS.
And he described some symptoms, correct?
Yes, I asked him what symptoms did he have, and he went through some symptoms.
Tell me if this, with your notes, constant numbness in his legs,
Yes, he reported numbness in the legs.
muscle spasms,
Yes.
and a lack of muscle control.
He said muscle flexibility and loss of balance.
All right. Did you discuss any prior head injuries with him last night?
Yes, sir.
And did, in fact, he show you the scars on his forehead and his face from prior injuries? Do you remember that?
Yes, sir.
And did he share with you a situation where he had been in a motor vehicle accident and had a head injury that required hospitalization?
Yes, he told me that in '97 he was in a car accident and had been unconscious for 2 or 3 days is what he reported.
All right, you on direct were asked questions about his seizure condition or disorder. You remember that? Just earlier today?
I may have been.
All right, well, you talked to him about it last night, correct?
Well, yes, that I did.
All right, and what did he tell you as far as when the last one he felt he had a grand mal seizure?
He said the last time was years ago when he was in prison.
All right, and didn't he also tell you that he had one out of prison, and his wife is the one that told him he had it? You remember
And
that?
he said that his wife had told him that she thought he had one. He said he doesn't know if he did or didn't.
Okay. Did you discuss with Mr. Toledo a previous marriage he had other than Miss Suarez?
Yes, sir.
And did he tell you that he had a daughter as a result of that marriage?
Yes, sir.
And did you discuss with him if he still had a relationship with that daughter today?
Yes, sir.
And what did he tell you about that?
He said that he did.
And he saw her, when was the last time he saw her?
I don't recall the last time. He did say that he was maintaining a relationship with her.
Did he tell you he saw her yesterday he had seen her?
I don't recall him saying that.
Okay. Judge, I don't have any other questions.
Thank you. Any redirect? Thank you. May the witness be excused. State, defense?
Yes, sir.
All right, thank you, sir. You may step down.
Thank you.
Folks, we're going to take
Have
a
a good day.
10-minute recess, use the restroom, and we're going to keep going, okay? Down there.
I do.
Make sure you sit down, speak closely to the microphone, please.
Okay, thank you, Your Honor.
Good afternoon.
Good afternoon.
Can you please introduce yourself to the courtroom?
Sure, my name is Dr. Heather Holmes.
All All right. And Dr. Holmes, what do you do for a living?
I'm a clinical and forensic psychologist.
All right. And tell us, if you would, about your educational background.
Sure. Born and bred in Florida, raised down south. I attended Marshall University in Huntington, West Virginia for my undergraduate degree. I graduated with a dual major in English writing and psychology. I then went to Loyola College of Maryland, which is in Baltimore, to get a master's degree in psychology, and then obtained a doctoral degree in psychology from George Washington University in Washington, D.C. Part and parcel, in order to get a doctoral degree, you have to do a one-year full-time internship in your area of specialty, and mine was in forensics. So I worked full-time in Central Florida in the Florida Department of Corrections, which is our prison system here, both doing evaluations of inmates as well as some treatment. After that, you are required for licensure in Florida to do 1 year full-time residency, postdoctoral, which I did at for 2 private doctors in Miami, Florida. And that was, instead of post-adjudication or with inmates, it was evaluation of pre-adjudicated defendants facing criminal charges, as well as some evaluations for police officers for fitness for duty, and some small civil work.
All right. And do you see patients on a regular basis, or are you just in court? Would you describe that?
I used to do therapy. I miss it, but when my second child was born, I decided to give up being on call for practical reasons, so that way I wasn't glued to a telephone in the evening. So currently, the majority of my work is forensic evaluations for people either pre-conviction or sometimes appellate work post-conviction. There's been some minor civil work, but I also do evaluations of children and adolescents for ADHD, learning disabilities, and gifted. So right now, 100% of my work is in evaluation and not in treatment.
All right. And in regard to that experience, have you had an opportunity to testify in court proceedings before today?
Yes.
And do you know roughly how many times you may have done that?
60, 70 maybe?
Okay. Judge, can I approach the clerk's bench?
You may.
I approach the witness, John?
You may.
I'll show you what's marked for identification as defendants. M. Mark, do you recognize that document?
Yes.
Okay. What does it appear to be?
It's my CV.
Copy of it,
Yes.
also known as a resume.
Yes.
Judge, defense for penalty phase purposes would move to admit Dr. Holmes' CV. Object.
Without objection, will be admitted into evidence. Thank you.
All right, Dr. Holmes. You were asked by the defense to participate and do some work in the case of State of Florida versus Lewis Toledo. Is that correct?
Yes.
All right. And you had an opportunity to visit the jail in Volusia County.
Yes, I did.
All right. And you've also had the opportunity to review some historical records that were provided to you by his defense team.
Yes.
All right. And within the historical records, did you review some prior hospital records?
Yes, I did.
Some prior school records?
Yes.
And some jail medical records?
Yes.
Now, these records have been admitted, and I'm not going to go into great detail with them, but there is some familiarity with it that I think would be applicable here. What were you, if you had to say, like what you were specifically asked to do as it relates to Mr. Toledo, how would you describe it?
Well, I was asked to do a psychological evaluation of Mr. Toledo, and it was sentencing.
All right, and do you have an area that you'd like to work in, dealing with bipolar disorders?
Well, I don't do treatment, and usually it's more of a medication management issue with that disorder, but throughout schooling, yes, we have been trained to detect bipolar disorder, and it was a unique place to go to school when I was at George Washington. Honestly, out of laziness, I lived closer to the National Library of Medicine than I did to my school, so I joined there. And they have what's called Bipolar Network News, and it is a free publication, and it's accessible worldwide, and they take all of the research that we had on this disorder, and they present it to you. So I've attended seminars there, and they also, at that time that I was in graduate school, the thinking was that bipolar disorder is something typically you develop in your late adolescence, early adulthood, and it was discovered through research actually outside of this country that there is something out there called childhood bipolar disorder, and so that was kind of where the research went. So I've had some special courses and trainings to detect differential diagnosis. In other words, is this ADHD, is this bipolar disorder, is this both?
All right, and from your review of the historical records in this case that were provided to you, did you find references to past diagnosis of Mr. Toledo having bipolar disorder?
Yes.
Now, bipolar disorder, that's a recognized disorder within the medical field, is that correct?
Yes, absolutely.
All right. And do you know roughly what percentage of the United States population currently would have such a disorder?
It's low. I mean, you're talking, and I don't remember offhand, but less than 4 or 5%.
Okay. Now, how does bipolar disorder affect someone's behavior?
It varies. I think it might be easier if I define and describe it,
Okay.
if that's all right.
Yes, ma'am.
If we think about diabetes being a chemical imbalance in your pancreas, you need insulin in order to regulate how your body metabolizes sugar. Bipolar disorder is an imbalance chemically in your brain. And so it's treated pharmacologically, it's treated with medication to help balance out the two parts of it. So everybody knows depression, that's where you're sad and blue. You can be sad because you lost your job. You can be sad because you're going through a divorce. You can be sad because of life changes. Or you can be clinically depressed to the point where you're suicidal, you're hopeless, you're unable to carry on or find pleasure in regular activities. So if we picture bipolar disorder like you would a seesaw, one end of that you experience depression, and the other end you experience either mania or a smaller form of that, a lesser form, which is hypomania. And mania is defined as an elevated mood. And not just elevated like you're happy you won the lottery. It is absolute intense, either euphoria or irritability. But it's an intensity of emotion, and it is coupled with a decreased need for sleep. Some people can go 1, 2, 3, 4 days without sleep and not feel like they need it. There's pressured speech. There's flights of ideas. They're very easily distracted. And they also have this inflated sense of self-importance, what we call grandiosity. So if you picture a car that you put in park and you put your foot down on the gas, the engine's revving, and there's not enough ways to expel that energy. So if we think again about a seesaw, depression being on one side and mania or hypomania being on the other, chemically, people with this disorder will vacillate between the two. They'll have a few weeks here, 2 weeks here, and again, it can either be euphoric and happiness that the engine is revving, or it can be intense, incredible irritability. So it really depends on the person and how that manifests.
All right. Is it common from your experience in studying that people with bipolar disorder have a difficult time controlling their emotions?
Yes, particularly in the manic or hypomanic phase, yes.
And how about difficulty controlling anger?
I mean, any emotion, it impacts your, particularly in cognition. It can, depending upon how it manifests.
Anger.
I mean, strong strong it is. Any strong any any emotion is where any emotion it is where you are is strong it is where you are strong it is where you a lot of times it's as they're coming out of the depression and they have more energy and they know that the mania is coming when they make these attempts, but it's very common with this disorder, yes.
All right. And can bipolar disorder, is it something that can be treated with medicine?
That's the first line of treatment, just like I was saying with diabetes. To stabilize something chemically in an organ in your body, the best way to do that is through medication. In other words, this disorder is highly genetic. It's not dependent upon what's going on in your world, so it's not something that you can solve just with therapy.
And did you see through the review of the records, have Mr. Toledo ever had been treated with medicine for his bipolar disorder?
Oh gosh, he's been on phenomenal amounts of medication, several different.
And we've heard a list of them earlier in the trial, but those would be medicines that a doctor has prescribed to him for this disorder, correct?
Some early on were for what they believed to have been ADHD.
Okay. And weren't there some drugs for depression too?
Yes.
All right. Now, can someone who has this bipolar disorder get it firmly under control with the help of the medication?
Yes, and they need to be monitored medically for, as we all know, when we turn 30 and 35 and 40, our metabolism changes. And so since you have to hit a particular therapeutic level in your bloodstream of this medication, you need to be monitored throughout, because sometimes you'll have too much of it and it can be toxic to your liver, or you'll have too little because you've gained weight or what have you. So yes, it can be absolutely controlled and managed through medication, but that medication management needs to be assessed and checked through blood levels by a medical physician.
All right, doctor, let me ask you this. What happens if you're someone that has bipolar disorder and you've been prescribed medicine and you're taking your medicine for a while, so you have it under control, and then you stop taking your medicine? What happens to you then?
You're never cured from this. A lot of times these guys get off meds. And I mean, I have colleagues that are lawyers, doctors that are prescribed these medications with this illness that have gotten off meds and have risked losing their license. It's not uncommon to get off the meds, but if the disorder is there, it will come back. Just like if you're diabetic and you stop taking insulin, you can't be cured of this. You need to be maintained medically, from what is found in the research for years.
And would you suggest that's something you would maintain throughout the rest of your life once it was discovered?
Yes.
Did you and Mr. Toledo discuss when you were with him whether or not he took medicine for bipolar disorder?
I asked him the medications he was prescribed currently, as well as what he could remember that he had been prescribed in the past.
Now, you are aware, as you sit here today, obviously, what Mr. Toledo has been convicted of, correct?
Yes.
All right. And from what you know, let me ask you this too. Were you provided some records from the trial itself?
Yes.
Did you receive a printout of roughly 15 pages of a series of text messages between Mr. Toledo and his wife at the time, Ms. Suarez?
Yes.
Did you also receive a transcript of a phone call between Mr. Toledo and someone named Miss Newell.
Sabrina?
Yes.
Yes, I'm sorry, the last name wasn't there for me.
Okay. Now, you didn't sit through the whole trial, so I'm not going to ask you more detail than that, but is the type of behavior that Lewis has been convicted of and your knowledge of the case consistent or inconsistent with someone with bipolar disorder?
I really can't say, because we have people with bipolar disorder who have never committed a crime in their life.
Well, that was going to be my next question.
Certainly, if you are not medicated and you have any major mental disorder, it makes you at higher risk for things like substance abuse and criminal activity. I mean, the research is very clear on that. But relating his specific disorder to this specific case, I don't think I can do that.
Okay. You are aware there are many people in society walking around today with bipolar that don't get involved in the types of crimes of conviction that we're here for today, correct?
Correct.
But you also would agree that many people who are convicted of these types of crimes do have this type of disorder. Is that fair to say?
I mean, I don't have the numbers, and I certainly don't have knowledge of every capital case that we have here in Florida, but I can say that the majority of cases that I've been involved in, there has been some mental health issues. It's fairly rare, just, again, in my limited experience that I've seen, I have, but that I've seen somebody who commits capital murder that doesn't have something in their background.
All right.
In terms of mental issues.
Okay. Are you aware if Mr. Toledo is on any medicine for depression as we're sit here today?
I don't know what he's on currently. I know what he was on when I interviewed him 20 months ago.
Was that the Wellbutrin?
No, when I saw him, he was on lisinopril for high blood pressure and Vistaril, which calms you down. Right. It's anxiolytic. And
do you have an opinion as whether stress in someone's life would have any impact or affect their bipolar disorders in any way?
I mean, you're already sitting at an elevated baseline. If you're at the manic or hypomanic stage, any outside stressors would certainly impact and could exacerbate that. Okay. If you're unmedicated.
All right. And that hyper or manic state, that's one side of the seesaw, correct? That
yes.
You described earlier. Okay. Judge, I don't have any further questions.
All right, thank you. Any cross-examination?
Good afternoon, ma'am. How are you?
Good afternoon. Well, thank you.
Good. One of the things about a diagnosis of a psychological disorder is that it relies very heavily on the patient's description of symptoms. Is that right?
Depending upon the environment in which it's done. If I'm sitting in my private office, then I trust that the person that is speaking to me is telling me the truth because they're paying out of pocket for it, and it would really be in their best interest to do that. In a forensic environment, I personally take nothing for granted that a defendant or inmate relays to me. So it's always up for question. So again, it depends on where you're collecting the information and what the situation is.
But in a more simple, in simple terms, you do have to rely upon a person's statement of what they're feeling and what they're thinking to determine where they may fit within your diagnosis. Very subtle deviations can sometimes make a large difference, isn't that right?
Yes, no, absolutely.
And so you do have to consider what they say.
You do.
It can't all just be historical records, and it can't all just be outward symptoms and physical manifestations. Sometimes it matters very much what a person says about how they're feeling or what they're thinking.
Yes.
Now, you're aware that the defendant has a history of being dishonest with mental health experts, is that right?
Yes, I've seen the records.
Yeah, and it has been repeatedly said by psychologists, psychiatrists, clinical workers that he has a history of malingering.
Yes.
He exaggerates his symptoms, right?
Yes.
Now, you're here today to talk primarily about bipolar disorders, I understand it, right?
Correct.
But you also recognize that he's been previously diagnosed within the prison setting with bipolar, granted, but also major depressive disorder and also depressive disorder NOS.
Yes.
And independent of the defendant's exaggeration of particular conditions or symptoms that he was feeling, the review of the record demonstrates that he was diagnosed with all three of these conditions sometime in the year of 2006 or 2007.
I'm going to trust your memory on that. I can't remember the years that I saw, but I did see all three of them.
Right, while he was in prison.
While he was incarcerated, yes,
Okay,
absolutely.
And he was incarcerated in 2006 and 7.
Yes.
Now, while he was in prison, and no matter his diagnosis, he was given medication by prison officials, right?
Correct.
Okay. He was counseled by mental health experts within the prison community, people that worked in the prisons and dealt with individuals with mental health problems.
Let me define counseling as someone who worked at the Department of Corrections. Sure. There is no true counseling in prison. It's a 15-minute every 6 to 9 weeks, according to what the Florida Department puts out, is required to manage and check in with somebody. On the rare occasion that there might be any counseling at all, it's usually done in a group setting. But there's no individual therapy as we would know it on the outside. They just don't have the money or resources for it. So it's not, I hear what you're saying, and it'll be listed as counseling, but the reality is it's a 15-minute check. How's your sleep? How's your eating? How are you doing? Any problems? To see if you're screening for the psychiatrist.
And I think counseling was probably a poor choice of words on my behalf, just because it's a term of art in your field. To me, it's a person coming by and talking with him about his symptoms.
Yes, there is contact with mental health staff. They have a master's level person that checks in.
Okay, and someone that would come by and tell him, hey, we're going to give you Resperdal today, or we're going to give you Wellbutrin today, things like that.
That would be a psychiatrist, but the master's level person that checks in with them would do so every 6 to 9 weeks, depending.
Okay. My point being, though, that someone has gone by and talked with him about the drugs that he's taking and why he would be taking those specific drugs.
I don't have the content of them, but he would have the opportunity in that session to ask questions.
Right.
Certainly.
And he even has the opportunity to refuse to take medication based on a myriad of personal choices.
Yes, unless you're at the CSU, in which case they can court order them.
Right.
But yes, if you are on the compound in general population and you decide you don't want to take medication, you can discontinue at any time.
And in fact, we've even seen his prison medical records that he accepted these types of drugs and refused other types of drugs.
Correct.
When talked to by someone with a mental health background.
Yes.
Okay. In fact, I mean, he was treated from everything from depression to sore muscles from basketball games that he played with other inmates. So, I mean, he got a lot of treatment. He saw people that were medically qualified during his time in prison. Isn't that right?
He interfaced with medical staff, yes, on a regular basis, absolutely.
I guess my point being there is the defendant, since at least 2006, had been diagnosed with these problems and was given treatment in prison. He had the same ability to seek treatment outside the prison walls, didn't he?
I mean, he has the same ability to seek it. Yes, absolutely.
If he was hearing voices or feeling depressed or feeling manic, he could have gone to see someone, couldn't he?
Absolutely. Intellectually, he has the capacity.
And he understood that he needed medication from his time inside, or at least that's what doctors told him.
Yes, I do believe when he was when he reached the end of his sentence, that he was on, he was given 1 out of the 3. They give you a 30-day supply. You then have to go make an appointment in your home county and try and get that medication renewed. The one he was on, he was having a lot of difficulty with. It was Remeron. It does have some side effects. So yes, he was EOS'd, but with 1 out of the 3, I don't know why. But he could have gone and asked within the county he's from, Volusia, he could have gone to a community mental health center and asked for different medication or for med review.
And my point being there is that if he were having any sort of mental health crisis in October of 2013, he could have gone to talk to somebody, couldn't he?
Absolutely.
And do you have any records to suggest that he did go talk to somebody?
No, in fact, I believe he was not medicated.
Okay. And so whose failure would that be? Would that be the system or the world or Louis Toledo?
Well, I'm certainly not here to assign blame to the system, the world, or to Mr. Toledo, but I mean, I hear what you're saying, and,
right.
And yes, intellectually he has the capacity to argue and advocate for himself, and he decided not to do meds when he was out of prison, yes.
And now you talked with Mr. Nielsen a little while ago about some people who have this disorder or mental health disorders are more apt to commit crime. Is that right?
Anybody with a mental disorder that's left untreated is going to have there's a higher incidence in that population of substance abuse and criminal activity, yes. Not specifically to this, but generally to all.
Wouldn't you agree with me, though, Doctor, that some people are just mean and terrible at their core?
Absolutely.
Thank you.
Let me redirect.
Thank you, sir. I forgot to ask you this. We've heard from different doctors this week, and that word malingering, just can you tell us your take on it and what it means? You've reviewed the records. How do you explain it to the jury?
Sure. Well, malingering is a psychological term, and it has one of two meanings. Either you are feigning or making something up, or you are exaggerating what is there. So when he's receiving diagnoses of NOS or depressive disorder, NOS, or bipolar disorder, and a diagnosis of malingering, it's because whoever is doing the diagnosis believes that there is some exaggeration of symptoms, and there's also something going on in mental illness.
All right. And I think you said a moment ago, but your understanding is that that date or the time frame, the summer, fall of 2013, that was one of the periods he was off his meds. Is that correct?
Yes.
All right. I don't have any other questions, Your Honor.
Thank you. Any recross? Thank you. May the witness be excused. Defense?
Yes, sir.
State?
Yes, sir.
Thank you, ma'am. You may sit down.
Thank you.
Defense?
Yes, sir. Call up Madeline Gonzalez.
Thank you. Make sure you sit down right there and then speak close to the microphone so that yours can hear what you have to say. You may proceed.
Okay, thank you, Judge Zambrano. Can you please tell us your name, ma'am?
Madeline Gonzalez.
All right, and do you know Louis Toledo?
I do.
How do you know him?
He's my cousin.
All right. And you're here today to support him, correct?
I do, yes.
All right. I'm going to ask you just a few questions. Do you love your cousin Louis?
I do.
You know that the jury has convicted various charges. You know that, correct?
Yes.
And despite that fact, do you still love your cousin?
Yes.
Have you had contact with him? Obviously, you had contact with him before the case, but since the case started years ago, did you maintain contact
Yes,
with
I
him?
have.
All right. Even when he's in jail?
Mm-hmm. Yes.
You have to say yes or no.
Yes.
All right. And is it your plan that you would continue to have a contact and a loving relationship with your cousin Louis?
Yes, we are.
All right. And is there other family that came also to support him today?
Yes, my daughters.
Judge, I don't have any other questions of Ms.
Anything
Gonzalez.
from the state?
No, sir. Your Honor, we have the first one.
Okay.
Jury's out of presence of the court, decide the jury room, Your Honor.
Thank you. You may have a seat. Mr. Toledo, it's my understanding from your attorneys that we're coming to the conclusion of the presentation of evidence by your side. And I wanted to once again give you the opportunity, if you wanted to testify in your own defense here as far as a penalty, and that you do have a right to make that decision. The right belongs to you. It doesn't belong to your lawyers. I know we've had extensive discussions over this on Tuesday, I believe. And at that time, you had gone back and forth. You indicated you didn't want to present any mitigating evidence, but when I confronted you with the fact that I may appoint an independent counsel to do that, you decided to allow your lawyers to do it for you. But I do want to offer you the opportunity to testify on your own behalf if you want to, or choose not to testify. It's entirely up to you. Did you get a chance to talk to your lawyers about this before we even get to the decision? Well, do you want to talk it over with them? Do you know you don't want to talk it over with them? Well, the jury is considering two possible sentences here, life in prison without the possibility of parole or death. It's entirely up to you to take the stand and say, well, answer the attorney's questions as appropriately and make a statement. I'll let you even do that if you want to. I'm sorry, I couldn't hear you. You don't want to testify? And you don't want to make a statement? And you don't want to talk it over with your lawyers anymore? You don't? Okay, all right, very well. Do you want to put on the record the things you wanted to do?
Yeah, I just have to call her back up briefly.
If we can have the lady, Mrs. Gonzalez, you can come up quickly. Uniform. Before the jury comes back in, okay. Let me take care of this real quick, and then I'll talk to you, yeah. All right, you may proceed very quickly.
I approach the witness.
You may.
Oh, this wasn't marked. You want to put it on? I'm going to approach the witness, Judge.
You may.
Will be marked as letter N. Do you recognize this document?
I do.
Sorry.
Pete, let's do this. Let's send the jury down. Yeah. Okay, you may proceed.
So, Adrian, did you say N? This will be marked as Exhibit N. Do you see this document?
Yes, I know.
You saw this earlier when you were here?
Yes, sir.
Right, and it's, what is it, a blown-up photograph?
Yes, of our family.
Right. Do you recognize the people depicted in the photo?
I do.
And do you see Mr. Toledo?
He's the first one on the left.
And these are other family members?
Yes.
Right, that's when he was a young boy, maybe 8 or 9 years
He was
old.
8. Mm-hmm.
All right. It's my understanding Mr. Toledo has elected not to have this introduced as evidence, so it will not be evidence, and the jury will not see it, but we will keep it for purposes of the record. Is this the only one?
Yes, sir.
Okay, anything else?
Can we just get his statement on the record that he does not, I know that you made the statement, the attorneys have made the statement, but I think it would be great for record purposes if Mr. Toledo.
Okay, well, I think we have it on, he nodded yes. I'll just put that on the record, but let me hear it from your mouth. You don't want the picture to be viewed by the jury. Is that correct, Mr. Toledo? Correct, okay, so that's satisfied. All right, thank you, ma'am. You may step down. All right, and is the state going to have any more rebuttal? No, sir. So we're done? Yes, sir. All right, this is what I'd like to do is, it's 4 o'clock. How much time do you think you would need to do a closing argument? State?
And I don't think it would be that, maybe 45 minutes, Judge.
Defense?
I don't know if it would be that long, Judge, but the problem is, I think we need to do a conference over what they're going to be allowed to argue.
Yeah.
Mitigators and all that hasn't really been hashed out. I don't want to argue something that's relatively not even going to be admissible.
Okay.
Judge, if it's possible, I guess the big concern is the scheduling tomorrow, right?
Yeah.
Just come back in and close and send them out, is that the problem?
Now, here's the issue. Mr. Johnson has a Spencer hearing before Judge Maltz in the morning, and I would like to very much accommodate Judge Maltz. Spencer hearing, given that it was already continued once as a result of this trial. So I was hoping to knock that off, knock the closing arguments tonight, and then have the jury deliberate tomorrow. The alternative is having the jury come in at, how long do you think your Spencer hearing might take?
Well, Judge, we're not going to do much of anything other than present some additional victim impact statements. I know the defense has got a number, at least one witness that they'll call. There's a couple of others that we're going to object to. I don't think Judge Maltz, but will allow them based on what I know they're going to testify to, but I don't know that for sure. So it's hard for me to say.
You think if we have the jury come in at 11:30, that would give you enough time for the Spencer hearing?
It's really almost impossible for me because it's out of my hands. It's the defense witnesses. We're not presenting any new witnesses in that case. I know that there is going to be one or two that will likely testify. There's a couple of others that we're going to object to. So if you held a gun to my head and asked, I know you're not doing that. That's a figure of speech.
I'm not doing that.
But I think that's just a figure of speech, Judge. Maybe not a very good one. I would say that's a safe bet, but I'm
Okay.
often wrong about predicting times.
I don't want to rush you, but I do want to get done. But let's just spend the balance of the day to go over the charge conference. I'm going to send the jury home, have them here tomorrow at 11:30. And we'll just start with closings at 11:30 tomorrow. So, and
And Judge Maltz may want, if we're not done, may take a break for us to do closings and then come back.
that'll be fine.
Yeah.
Do the opposite. You could actually review the closing argument at 8:30, and finish, and do this.
No, I don't want to do that. I'll just have the jury come back in. What we'll do is this, we'll be in recess for a few minutes. I'm going to go excuse the jurors, explain to them that there's a possibility of sequestration again to bring their clothing and work to park and all those things. And then we'll come back and do the charge conference. If you want to take him so he can use the restroom when I come back, it'll take me about 15 minutes to take care of that. And I'll see you. Instructions that I will be giving the jury tomorrow. That's the basis of our meeting here. It is entirely up to you to stay, or if you want to go back and get your hot meal, you're welcome to do that. But I don't think I'm going to be ordering a hot meal for you. So, and we might be done here in maybe about an hour and a half. So it's entirely up to you. Do you want to stay or you want to go? Okay, very well. Then go ahead and take them. All right, let me give you a heads up. If you go to line, what I did is I took the instructions from the Supreme Court's website, and then I tweaked them to fit our situation. There was one instruction that I had to take. Well, you know what? Let's just go. Let's just go from the beginning. All right. The introductory instruction lines 1 through 6. This is a standard instruction. Any objection to that? All right. You do see my annotations on the right-hand side, right?
Yes, sir.
You're able to see those? I put notes whenever I had questions. That doesn't make a difference. Okay. Lines 7 through 11. In making your decision, you must first unanimously determine whether the aggravating factors, so on and so forth, until line 11. Any objection to that?
No, sir.
All right. Okay, and then I split count 1 and count 2. In other words, I will read count 1 with all the aggravating factors, and I'll read count 2 and all the aggravating factors.
Yes, sir.
And then I join the mitigating circumstances to apply to both, and I put an explanation that the mitigating circumstances apply to both. And you'll see that later on. Count 1 relates to Michael Otto. Count 2 was Thalia Otto, okay? All right, the aggravating factors alleged in count 1 is that Mr. Toledo was previously convicted of another felony involving the use or threat of violence to another persons, okay? And I put the 3 that fit the 1 conviction, and I got that one. Now, there was a burglary conviction that was floating out there.
That was for impeachment only if he took a stand.
Okay, so that,
I don't find it to be an aggravator.
all right,
I would make a grammatical change to line 15.
yeah,
Because convicted of another A felony.
yeah. Okay, let me,
Have a change as to line 19.
hold on, let me make the changes as I go. Line 15. And then what, the other one?
On line 18, I would suggest the deletion of the word "and" at the end of the line. And then on line 19, add "and" there because in including the prior violent felonies, you didn't include the aggravating circumstance of the contemporaneous killing of Ms. Flores.
I understand that. So I wanted to make sure that you guys wanted that included.
Yes, sir.
Okay, and then where you want that as number 4?
Sure, yes, sir.
And how do you want it phrased?
The way I wrote it was just second-degree murder as it relates to Ms. Suarez, but I would defer to the court in the phrasing of the instruction.
And what says the defense?
So we object to the first degree, which is the fuel of time. And time is a factor in deciding it, so we're objecting to that, aggravating factors because the element came from self-harm. Being used as suicide.
Okay, and I ruled that would be, that it would be admissible and considered by the jury as an aggravator, so.
Judge, Mr. Johnson raises another good point, is that the contemporaneous killing of the other child, whether we're working on Michael's instruction or Toledo's instruction, is yet another murder.
Well, you tell me.
And so, yeah, add another paragraph, or another paragraph, paragraph 5, that says the first-degree murder of Toledo Otto in the Michael Elijah count, and then when we get to the next count, modify the name.
Okay. Any objection to that?
I think I understood what they're saying. In addition to support this first aggravator of another capital felony or violent felony, they want to not only put in Eric Trailmini's evidence, but to support that, like when they're arguing for Michael, they want to say Talia, and when they're arguing for Talia, they want to say Michael. Is that correct?
Yes.
All right. Well, Judge.
I know. The case law allows it.
I know. Tough
So-
for the defense. We are going to object. It's double dipping, plus there was no evidence to suggest which one's first in the girl's degree, so we definitely need to object to that.
Okay, then I'll give it, but I need to modify then line 15 because I took out the word capital felony out of that. Another capital felony.
They have, as I understand this, they're going to have 3 different ways to try to prove that aggravator. That's the position of the state. Right?
Well, we'll have,
Well, 2 for each. 2
Yeah.
different ways for each child.
essentially.
Judge, we do object, I know it's the case law, but I think the case law is silly, because we can't put one.
Well, do you want me to,
It's the contemporaneous killing of one, the contemporaneous killing of another, and then the Eric Fraley.
But for each child, you can't argue 3, you can only, you have to have 2. Now, the wife's,
Wife,
she's not capital.
child, violent felony.
So there are 3 ways.
Yes.
correct.
Yes.
The 3 ways is Mr.
Child,
Pra,
1 Eric, and 1 wife.
correct.
Case law, Judge, you understand?
But I need to modify, I need to take a look at the jury instruction because the words another capital felony has to be added back in.
I would say another capital felony and/or a felony involving the violence of another person. I don't want to use just one because you don't have all of them. But
I'm just gonna look at the standard. I'm gonna use the standard. I need to pull it up, though. Okay. The standard reads, the defendant was previously convicted of a felony. Oh, no, that's not it. Was convicted of another capital felony and/or a felony involving the use or threat of violence to another person.
If I could place one other further objection on the record as it relates to the state's ability to argue this to the jury, plain reading of this aggravator says a felony doesn't address multiple felonies. I know you're ruling on respecting the meaning of.
Say it again?
If you read the sentence, it says the defendant was previously convicted of another capital or a felony. It doesn't say 2 or 3 felonies. We would argue that anything more than 1 felony is unnecessary and cumulative.
Well,
I understand you.
yeah. So you'll read, Mr. Toledo was previously convicted of another capital felony and/or a felony involving the use or threat of violence to another person. The crimes of armed burglary of a dwelling, robbery with a firearm, kidnapping while armed with a deadly weapon, second-degree murder as it relates to Yesenia Suarez, first-degree murder as it relates to Thalia Otto.
describing those as felonies involving the use of violence.
Say it again?
You're describing all of those as the latter category, which is felonies involving the use or threat of violence to another person.
Correct.
However, the first-degree murder would really fall under the definition of capital felony. So I don't know if you have to distinguish that definition or not. I don't know how you read that, but how the standard instructions represent the correct statement of the law.
I'll tell you what, I can just put it in parentheses and call them felony, and then one of them called capital felony. And they can look up and determine whether it's a felony that involves. I can call it felony, armed burglary of a dwelling, felony robbery with a firearm, felony kidnapping while armed, felony second-degree murder, and then capital first-degree murder. Capital felony, first-degree murder. That way they know there's only one capital and remains are simple felonies. Any objection to that?
Leaving in the last language there, or felonies, or all felonies involving the use of threat of violence to the person.
Hold on. Let me do this. Okay, so identified each as a felony. Okay. Okay, and then now the last line. I'm just going to, capital felony and felony, all felonies involving the use of, I think it fits. I don't think it needs further clarification. All right. So that takes care of aggravator number 1. Aggravator number 2, the first-degree murder was committed for the purpose of avoiding or preventing a lawful arrest. I removed some language on this one. I eliminated escape language because I thought it was inapplicable. Any objection to that? Huh?
We object to this aggravator.
Okay.
We don't believe that the state has made the pressure for it. The evidence for this must demonstrate beyond a reasonable doubt that the sole or dominant motive for the murder was the elimination of a witness. Proof of intent to avoid arrest and protection must be very strong, not based on mere speculation. So the speculation of this, what happened and why he must have done it, is not proper evidence. There's a heightened standard of proof for the avoid arrest aggravator that requires more than a simple inference that the defendant might have been motivated by the concern to eliminate a witness. And the mere fact that the capital murder victim knew and could identify the murder without more than insufficient to prove the avoid arrest sentencing mitigator. So those are simply the reasons that have been given. There hasn't been a heightened showing of motive. There hasn't been a dominant motive at all presented by any evidence, any direct evidence. The circumstantial evidence, as I understand it, is that Mr. Toledo said that Mr. Jackson did it because Mr. Jackson was on probation. There hasn't been one single offer of proof other than to say that
Other than Mr. Jackson saying he didn't do it.
Mr. Jackson said he did do it, but there's not another offer of proof to say what did happen. And so what you're forced to do circumstantially is believe that Mr. Toledo did what he said Mr. Jackson did. There hasn't been any proof of that at all. And so where we're at is that we're stacking inference on inference, that Mr. Toledo must have been Mr. Jackson, and that what he did was what Mr. Jackson said what he said Mr. Jackson did. There's no fact in that inference at all. I understand that the court would say that based on what order Mr. Toledo said things happened, we give an inference of premeditation, but it doesn't give an inference of a heightened standard of proof to avoid arrest. That doesn't appear in the evidence. And so we would object to that aggravating factor being given at all without some offer of proof to show what the facts actually are, rather than you just denying it out in. We don't know for the record what the facts actually are that would support that.
All right. I'm going to overrule the objection and go ahead and grant it. I did some research, and case law that I read supported this aggravator to be given. So I don't think there's any modifications to be done to it. It's just a statutory language other than the lawful or escape language that I took out. All right, aggravator number 3. First-degree murder was committed in cold, calculated, and premeditated manner without any pretense of moral or legal justification, and in the definitions which are standard. I don't think I need to do any modification to the text about an objection to it.
Really, this says no. We really object to them all, but we
Really object to this one.
this is both.
With capital really.
Thank you. Judge, this is, I'm just trying to pull up the case so I can get down to this in front of the court. This is Walls versus State, 641 Southern 2nd.
Dan, can you do me a favor? I left a green book on the table in the room there where we eat lunch. You mind getting it?
Would you like me to wait?
No, go ahead, yeah.
641 Southern 2nd, 381 Walls versus the State of Florida, and then a couple of other cases after that.
Hold on, let me look it up. Sure. 641 Southern 2nd.
381.
Thanks. Walls versus State?
Yes.
Yeah.
So this is the general list of the predicate. And then I have some other case law to support our argument. In the body body of the case, headnote 9 starts the predicate. There are 4 elements that must exist to establish cold calculated premeditation. This is under headnote 9.
Hold on, let me, there you go. Under head note 9,
Yes, sir. In the body of the case.
okay?
The first is that the killing was the product of cool and calm reflection and not an act prompted by emotional frenzy, panic, or fit of rage. The second element is in headnote 10. It requires that the murder be a product of a careful plan or prearranged design to commit murder before the fatal incident. So the emphasis there is on a careful plan or prearranged design to commit murder before the fatal incident. Third, the defendant has to have a heightened premeditation, which is to say, premeditation over and above what is required for an unaggravated first-degree murder. And then lastly, no pretense of moral or legal justification. Further, Your Honor, the case law suggests the case law suggests that in Hoskins versus State 702, 202, that cold calculated premeditated heightened premeditation is usually used for contract cases and execution. That's not this. And in Altersberger versus State 103, Southern 3rd, 122, the cold element generally has been found wanting only for heated, wanting meaning not there, only for murders that are heated, and murders of passion, which the loss of emotional control is evident from the fact. So we don't believe that the state has made the predicate at all for this. First of all, there's no evidence whatsoever of any kind of cold premeditated design, not any. And the facts of the case actually are the opposite, that this was done basically as it was described. If Mr. Toledo is convicted now of murdering his wife, that's second-degree murder, which was an emotional crime, not a premeditated crime. All of the evidence that led up to that killing, which would be the killing of his wife, was about how mad he got and how angry he was over the fact that she was having an affair. And what appeared to be the last argument was that she wouldn't cooperate with the call to Mr. Dredden. That's the last known evidence of any kind of intent. The only other evidence of intent is that he snapped. First-degree murder, premeditation, he's been found guilty about. So our argument would be he had no time for a heightened plan. This was definitely an emotional murder. It's not a cold, calculated setting in which he had a heightened plan, in which he executed some sort of premeditated, aforementioned plan before the murder. There's no evidence of that at all. And so this aggravator simply doesn't apply based on the elements and based on the case law. There's simply no way. There's no heightened premeditation. That's what more premeditation is required for that than anything. And premeditation that got him convicted of first-degree murder isn't enough. I know you know that already, but I want to make sure that the record says that. These cases are pretty clear about this. Heightened premeditation is much different than the regular premeditation for murder. In the Hoskins case, it actually says the Hoskins case is a circumstantial evidence case. I could read the evidence that the state tried to put in as support in the Hoskins case, and it would sound a lot like this case. But in the Hoskins case, under the head notes in the body, 11, 12, and 13, the Hoskins case says, generally, this aggravating circumstance is reserved for execution or contract murder or witness elimination type murder. Simply proving a premeditated murder for purposes of guilt is not enough to support CCP. A greater deliberation or reflection is required.
There's no plan here. There's nothing here that, there's not even any evidence of a plan. There's not any evidence at all of premeditation. It's our, but you've been convicted of that, so our argument now is that a heightened plan certainly isn't in any of the evidence. It's not even circumstantially proven. We would get to the court doing that.
What says the defense? I mean, the state.
Well, Judge, if it was, we were only talking about the murder of Yesenia Suarez, we'd agree with defense counsel, but we're not talking about Yesenia Suarez, we're talking about the children. When you look at this, this aggravating circumstance, you have to look at it in the context of, how these children were killed. The children were not killed until after the wife was killed. The only explanation for that is that because the children did not do anything to the defendant, but that he killed them in order to eliminate them as witnesses. And that in and of itself requires special calculation.
Witness elimination is a different aggravator.
That's right, Judge. But when we're talking about the purpose for which someone is killed, there is a calculation that's going on. And that calculation may be different in different circumstances. It just so happens to be here.
Okay, anything else? Our materials cite both the Lynch case and the Walls case, and it quotes extensively from Walls, and I'm going to read it out loud. It says, a CCP aggravator applies when the evidence supports each of the four elements described in Lynch. First, the murder must have been cold. This element has been found wanting only for heated murders of passion, in which the loss of emotional control is evident from the facts. Second, the calculated element applies in this case where the defendant arms himself in advance, kills execution style, plans his actions, and has time to coldly and calmly decide to kill. A plan to kill may be demonstrated by the defendant's actions and the circumstances surrounding the murder, even when there's evidence that the final decision to kill was not made until shortly before the murder itself. Third, heightened premeditation can be established by examining the circumstances of the killing and the conduct of the accused. The CCP aggravator can be indicated by circumstances showing such facts as advanced procurement of a weapon, lack of resistance or provocation, and the appearance of the killing carried out as a matter of course. Taking a victim to an isolated location or choosing an isolated location to carry out an attack can be indicative of a plan or prearranged design to kill. Lack of resistance or provocation by the victim can indicate both a cold plan to kill as well as negate any pretense of justification. The manner in which the murder is carried out can also indicate a cold and calm plan. Finally, the murder must have been committed without any pretense of moral or legal justification. A pretense of moral or legal justification is any colorable claim, at least partly, on uncontroverted and believable testimony that, but for its incompleteness, would constitute an excuse, justification, or defense as to the homicide. In this case, we have a sequence of events that I think is well defined. Your client says he killed the wife first. What happens next is that the children must have been killed. You're saying that's an inference. I think the jury has found that there's sufficient circumstantial evidence that he committed the killings, as they came back with a verdict of guilty of premeditated murder. Taking those facts and that one inference that the jury has now made it into a fact, how do these children get killed cannot be described by any other means as in a cold, calculated, and premeditated fashion. Because the chain of events could have ended with the death of Yesenia Suarez, but continued thereafter with a purpose. And the description of the killings of the children was with an axe, at least as to one of them. There was no description as to the second one, but with with the first one was a description was that the child was killed with an axe. So I believe that the aggravator does fit, and go ahead and give it as, yes, sir, I understand. The language itself over the objection, do you have any changes you want to make to the language? It's a statutory language. I don't think I modified anything in it. Okay. So there's an objection to the third aggravator based upon Mr. Dean's argument. The court will give the aggravator. Aggravator number 4, Michael Elijah Otto was a person less than 12 years of age. No objection, no real objection to this one. All right. And then number 5, Michael Elijah Otto was particularly vulnerable due to advanced age or disability.
You removed the advanced age or disability?
Yeah, I don't know why. I'm reading the old one.
Yes, sir.
Let me see. Actually, I didn't remove it in count 1 for some reason in mine.
Yeah, count 1 it remained, but count 2 it was removed.
Okay, Michael Elijah Otto was particularly vulnerable because Mr. Toledo stood in a position of familiar or custodial authority over the decedent, Michael Elijah Otto.
You believe that aggravators 4 and 5 were double?
And I did that down below. We're going to get to it, but I've already put it in there.
You already agree with that?
Yes, sir. I do. Do you have any objection to that?
I don't believe it's double, because you could have a victim who got less than 12 years of age that's not in a position where the defendant is in a position of familiar or custodial authority.
You could, but in this case, it is.
Right.
You have it. The reason why the child is being cared for, the parent, is because he is a child. So that's my understanding and my belief that it is a doubling of the aggravator.
The reason I don't believe it is because...
Go ahead.
Not a separate event.
It is one event.
The reason I don't believe it, I'll just hear me out. The reason is because both of these can stand on their own. You can have a child who's 13 years of age that does not meet the less than 12 years of age aggravator.
Don't speak in hypotheticals, speak in this case. Do you have a 13-year-old in this case?
No, I'm just saying, when you're saying doubling, yes, almost like the double jeopardy kind of argument. You know, if each crime can stand on its own, then it's not double jeopardy. Here, each of these aggravating circumstances can stand on their own.
The way I see it, I already put it in there as emergent. I did some research on this because I know it would be an issue. I'll give you an example. If you look at the next victim, less than 12 years of age, the court found in a case called Hutchison versus State that it was improper to double, it is improper doubling, meaning that to get two separate aggravators, when you have the offense of aggravated child abuse at the time of the murder. How is that any different from this?
I have to read the case.
Well, I can give you the site, 533. It's Lukehart versus State, 776 Southern 2nd, 906.
Please do one more time.
Luke Hart versus State, 776 Southern 2nd, 906, at page 925. It's a Florida Supreme Court from the year 2000.
What that number did you say, or page number?
Huh? 925. Our materials read, in Hutchinson versus State, the Supreme Court of Florida found no harmful error in the trial's court handling of the aggravated child abuse as an aggravating circumstance because the trial court merged the factor supporting this aggravator with the aggravator that the victim was less than 12 years of age. And under our circumstances, this is a stepfather killing their child. I can do some more research on it, but I'm inclined to agree with the defense that these two should be merged, and I'm inclined to merge them. If you want to do research overnight and then let me know, you're welcome to do that.
Thank you for the opportunity.
So, but that's going to be my ruling for now.
I can tell the court I do not want to make a mistake on it. Sure.
I'm sorry?
I'll just say, if it is, then
Well, I'm just
mistake.
letting you know that I'm inclined to do that. Okay, and then count 2, on the aggravating circumstances, I did the same thing as count 1. All objections, you want to raise your objections identical?
Yes.
All right, so the objections that were made to count 1, the court accepts as to count 2 because there's identical issues that relate to both of them, so they, for purpose of the record, they have been made. We've had discussions on count 1, like I said.
Just going back to the doubling argument, I just want to just clarify, if we decide that it is doubling, that does not prevent us from being able to argue the weight of those two aggravated, even though they double.
So long as you tell the jury that they can only count it as 1.
Of course.
And that's the instruction, so. Let me just make sure that count 2. Okay, I think I got it. All right, and then we're going to pick up on line, what you have would be line 85, I think. Is that where we are? Okay, any objection to that? That's a standard language, line 85. Okay. And then 95 through 99, a reasonable doubt as to the existence of an aggravated factor may arise from the evidence.
Sorry, there's line 99? 95.
Yeah. Adrian, I'm printing this so you can have it as part of the record for the charge conference. Just label it charge conference. So, all right, and then, line 100 through 104 is the next paragraph. A finding that an aggravating factor exists must be unanimous. That's a new state of the law. Lines 105 through 108. If you do not unanimously find that at least one aggravating factor was proven, that's okay? Okay, lines 109 to 113 is the last paragraph of that jury instruction. If, however, you unanimously find that one or more any objection? All right, okay, and then we go to mitigating circumstances. This is a standard, and I added the instruction. This is applicable to both counts 1 and 2. This is a standard one. If you go down to line 126, I included all of them, and I need the defense to choose.
Yes,
Okay? So you,
I have my first proposed instruction.
okay, let me take a look.
Start line 117.
117?
Yes.
Let me take a look.
This would be the sentence before what you have in the standard.
Okay, let me see. Your first proposed instruction says, unlike aggravating factors, the finding of a mitigating factor, I think I would call it a circumstance, yeah, does not have to be unanimous. Each juror makes an individual decision as to each mitigating circumstances. Any objection to that?
Well, I think our preference is to stick with the standard instructions, and I know that I've briefly spoken to Mr. Dean before. I thought that this language is sufficiently covered with, disagreed with that, so.
You know, it's not an inconsistent statement of the law,
Well, I agree with that.
so decision as to each mitigating circumstance. Okay, unlike aggravating factors, finding. Okay, all right, so I granted that one, and I put it in.
I have my next one.
Where does that one go?
Come right after what you said.
Aggravating factors must be agreed upon unanimously to be applicable. Mitigating circumstances do not have to be agreed upon unanimously to be applicable to a juror's decision. I think that's just already in there.
I'm saying that it's not, so I just want to propose these, because there is, what you just put in, on my reading of the standard instruction, will be the only time that it's in there that the mitigating circumstances don't have to be found unanimously. In the instruction that I read, that you provided,
Yeah.
it alludes to it. It says things like each juror can decide. But what happens is that when you read the first part about aggravating circumstances, and it is right up front that they have to be found unanimously. We just finished a phase in which they had to find things unanimously. And in this part, they don't. And I just want to we say it over and over again. You actually instructed them twice, at least twice in the guilt phase. You're going to already tell them again that they have to be unanimously finding certain things over and over again to proceed with death penalty.
How is number 1 different from number 2?
It is,
I think you're saying the same thing twice.
well, it's different in that the overall, when you said, what my goal was is that each juror can decide, and then even when you decide individually, you don't have to be unanimous about this. And I think that I'm going to try to say that more than once. Just like we say more than once, you have to find when they have to be unanimous.
Okay.
You have to find it. So I'm opposed.
I'm going to deny number 2. Okay, I think number 1 covers it, and the rest of the instructions cover it. Number 3, where would that one go?
We got it.
Huh?
It's further.
Way down, okay, so the rest of the paragraph is okay? Okay, and then which of the mitigating circumstances you want to, the statutory mitigating circumstances?
Judge, the only one I believe that fits the evidence statutorily is the, number 6, inability to conform to the constraints of the law is substantially impaired. That's from Dr. Mann.
6 and 8. Well, 8 is basically the catch-all.
Well, yeah. What I have here, Judge, just so you understand, sir, this is a working product. I have a number proposed non-stat mitigators, but what I would ask with the court's permission, since we're going to have this little gap tomorrow, we'll get it typed up, go through and take off what I originally had put in, which never materialized, and then submit it very early tomorrow morning via email to your office. If you want to do it like that, I don't know how else you want to do it.
I'm going to be real busy in the morning, and I think the state ought to have the list. I don't have a problem giving you some time tonight,
Okay,
but it has to be shipped out tonight,
okay.
so I can incorporate them into here, and then,
All right, I just, not having an office up here.
no, that's fine. I mean, I don't mind giving you the time, but I think out of fairness to the other side, they ought to have the list tonight so they can prepare themselves.
Is there a particular time we can get it by?
Send it to Ryan or to Mark?
Send it to me because I'm doing closing. You can send it both of us. Just send it to me and I'll get it.
Okay.
It's the same format with Johnson and
I go to bed at 7, so,
Hey, I'm right with you there, Judge.
when the sun goes down, I'm like a chicken. I find my little safe space and go to bed.
We can do what you asked.
All right, okay. And then it would begin then the following paragraph below there. It is the defendant's burden to prove the mitigating circumstances exist. And that's at line 152 in what you have. Any objection to that paragraph or the last paragraph which begins at line 153?
Not a mistake.
I don't have a paragraph. I have one long statement.
You should have had 2 paragraphs, 152 through 16, I'm sorry, 152 through 162, and 163 through 166.
I have 150, it's one long paragraph to 160. And then 161 to 164, is that?
Then I got off somehow because I must have made a modification after.
All of our lines are off like one, so.
Well, maybe when you added the sentence, maybe that.
I think it is when I added the very first. So,
I have, it is the defendant's burden to prove the mitigating circumstances exist. I explained before in these proceedings, is that what you're talking about?
yeah. Right. And then the very next paragraph. Actually, I think I know where I made a mistake.
I'm sorry, I'm at 157 for proposed instructions.
157?
Yes, sir, it's going to be number 5, proposed number 5.
Okay.
In line 57, line 157, the sentence that says any juror persuaded,
Okay, hold on, let me see if I can find it. Yeah, it's mine 158, go ahead. Any juror persuaded as to the existence of a mitigating circumstance?
the proposal that I made was any any juror may be individually persuaded.
Well,
That's actually the law.
yeah.
It does say any juror, singular.
Yeah. Oh, I understand. It's an oxymoron, but, I mean, you have two words saying the same thing. Any juror includes any individually.
Not in this circumstance, Your Honor. The way this is set up is that those jurors...
I'll add it.
Also brings in 158.
Hold on. I gotta make the correction before.
Yes.
I think grammatically it makes more sense to say any juror individually persuaded rather than all the rest of that.
I'll just give it like you wrote it. Any juror may be individually persuaded.
But if you read it all the way through the end of the sentence,
As to the existence of a mitigating circumstance, must consider it in this
you have
case.
like two verbs going on. Any juror may be persuaded as to the existence of a mitigating circumstance. Must consider the case. That's why I'm saying any juror individually persuaded as to the existence.
This is the Supreme Court language,
I'm saying that adding the language of defense is requesting.
and English is my second language. I just want to point that out. Any juror may be individually persuaded as to the existence of a mitigating circumstance, must consider it in this case. Just like it is?
Any juror individually persuaded, it's not in there. So if you put individually in there, any juror individually persuaded as to the
You want to get rid of the words may be?
That's fine. Any juror
Individually?
Which I think is confusing because there's two. Verbs in that sentence.
Is that against the law?
Well, I mean, I know that none of us are English majors, but language does matter. And whenever we're trying to keep the jurors from being confused,
I think the words maybe need to come out. So it would read, any juror individually persuaded as to the existence of a mitigating circumstance must consider it in this case. Okay, so it's granted, partially granted, or
I
modified.
have another one right next to it.
Okay?
The same thing. Further, this will be line 158 for me, but maybe 162 for you. Further, any juror, the next sentence, further, any juror, and I put in, I said, any juror may individually consider. But if you want to say,
Okay, what instruction is that one?
I'm sorry, number
6, I'm sorry, okay. Okay, further,
any juror, individual may consider it in circumstance. You put it in there like that, and I'm applying that.
okay, I'll just go ahead and insert the word individually. Granted is modified for jury instruction number 6. That was the same thing for jury instruction number 5. Modified, granted but modified. All right. Anything with respect to the last paragraph?
Yes, sir. I'm on line 160 now. For me, I think you're ahead of me.
Yeah.
And that's number 7.
Okay.
This says mitigating circumstances are found or not by each juror and their existence need not be established unanimously.
I think this has already been covered.
It will be the last sentence.
You want to add that sentence after the word process?
I want to add that sentence after the word mitigating. On line 160.
No, I'm off a little bit. So tell me, read me the,
162, it would be the sentence we just modified, right there, where you stuck in individually. I would want the
Oh, so we're still in the paragraph above?
Yes, I'm sorry.
Okay.
So it was at line 160 for me. I'm not sure you're,
So it will read further, any juror individually may consider a mitigating circumstance found by another juror, even if he or she did not find that factor to be mitigating. Mitigating circumstances are found or not by each juror, and their existence need not be established unanimously. That's been there before, the last part.
And nothing prevents the defense from arguing that. It's been said at least twice and emphasized with two insertions of word individually.
hasn't been said for.
This is confusing for me. Mitigating circumstances are found or not.
Well, I
by-
didn't want to say, I wanted to give both sides of it, so maybe I'm going to articulate about that, but
Yeah.
the thought is I want it to be, you can find it or not find it individually. And you don't have, it doesn't have to agree with anyone else. That's the thought, so.
Wasn't that the first line? Yeah, I'm going to deny this one. That's proposed jury instruction number 7 is denied. Okay, now to the last paragraph before we get to merger. Your decision regarding the appropriate sentence should be based upon proven aggravating factors and established mitigating circumstances that have been presented to you during these proceedings. You will now engage in a weighing process. Okay, no objection to that? Merger, this is, I modified this, so let me read it because you don't have it. Pursuant to Florida law, the aggravating factors of victim is less than 12 years of age and victim was particularly vulnerable due to age are considered to merge because they are considered to be a single aspect of the offense. If you unanimously determine that the aggravating factors of victim is less than 12 years of age and victim was particularly vulnerable due to age have both been proven beyond a reasonable doubt, your findings should indicate that both aggravating factors exist, but you must consider them as only one aggravating factor during the weighing process that I am about to explain to you.
There's one problem with the language, Judge, and that second aggravator, that the victim was particularly vulnerable, is not due to age. It's due to the position that the defendant held over that victim.
Oh, that's true because it's familial. Familial, yeah. Well, the title is due to age, but tell me what do you want to call it?
Well,
Because we eliminated the age side of it, so,
vulnerable due to familial authority, right?
okay, let me see.
How did you put it in your aggravator?
He cited the statutory language, which includes age, blah, 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 blah. Familial custody is the last one of it. Age, incapacity, and all those things. But I took those things out because they're not applicable.
Well, and this gets to my argument about why it doesn't double. Of course, we're going to do some research on it. The age doesn't do with a person of young age. It has to do with persons of advanced age. So you have 3 different categories of vulnerability with regard to your victim. Due to advanced age is the first one. The second one is disability, and the second one is because the person that the defendant stands in a position of familial or custodial authority over that person, which has nothing to do with age.
Excellent. Now, give me a case.
While you're working on an inspection.
All right? So I'm gonna give it.
I want the language used.
Yeah, we need to change the language. I agree with you on that part, but I'm disagreeing with you on the fact that you believe there's no merger. You might be right.
Well, and I'm not trying to relitigate that. I'm just saying there's a lot of discussion about using age as the language in here, and that's not the appropriate.
This is the only place in the world where we can just say, I'm not trying to relitigate that, and then we relitigate that. All right, so due to, let me see how I got it up above. It says because Mr. Toledo stood in a position of familial or custodial authority over the decedent.
Yes, sir.
Okay. Then I'll just have to include that whole language. Let me copy it and paste it. Let me read it, okay? Pursuant to Florida law, the aggravating factors of victim, I want to put this in quotes, just so. Victim is less than 12 years of age, and victim was particularly vulnerable because Mr. Toledo stood in a position of familial or custodial authority over the decedent. I can just get rid of over the decedent, Thalia Otto. I don't think I need to have that. They're just over the decedent.
Yes, sir.
Are considered to merge because they are considered to be a single aspect of the offense. If you unanimously determine that the aggravating factors of victim is less than 12 years of age and victim was particularly vulnerable because Mr. Toledo stood in a position of familial or custodial authority, have both been proven beyond a reasonable doubt, your findings should indicate that both aggravating factors exist. But you must consider them as only one aggravating factor during the weighing process that I am about to explain to you. That'll be for now until you can find me a case. Okay? You must weigh all of the following. That's the next language. A, whether the aggravating factors found to exist are sufficient to justify the death penalty. B, whether the aggravating factors outweigh any mitigating circumstances found to exist. And C, based on all of the considerations pursuant to these instructions, whether the defendant should be sentenced to life imprisonment without the possibility of parole or death. Okay so far?
Yes, sir.
The process of weighing aggravating factors and mitigating circumstances is not a mechanical or mathematical process. And then that whole paragraph. Any objection to that? The paragraph ends with, the law neither compels nor requires you to determine that the defendant should be sentenced to death.
No objection.
Okay. Hearing nothing, moving on. Once each juror has weighed the proven factors, he or she must determine the appropriate punishment for the defendant. Jury's decision must be unanimous if death is to be imposed. To repeat what I've said, if your verdict is that the defendant should be sentenced to death, your finding that each aggravating factor exists must be unanimous. Your finding that the aggravating factors are sufficient to impose the death must be unanimous. And your finding that the aggravating factors found to exist outweigh the established mitigating circumstances must be unanimous. And your decision to impose a sentence of death must be unanimous.
If there, you have that
Say it again?
decision, if to impose,
Yes.
you say if now? It's on my line 198.
Looks like it's just a typo.
Okay. Your decision to impose?
Maybe it was supposed to be it was to impose.
Must be unanimous, and the decision to impose a sentence of death must be unanimous. There's the word if there.
Yeah, I corrected it.
I have two last requests
Okay, coming up.
that would come in this paragraph.
Next one coming up, or this one we just read?
One we just finished.
Okay?
So, This would be at the beginning of the paragraph, which is my 191, which starts with once each juror has waived. So before that, I would ask the court to say on instruction number 3, because the decision to recommend life or death is an individual decision that does not require the jury to be unanimously
To be unanimous.
To be unanimous. Once each juror.
This is a misstatement of the law. Because the decision to recommend life or death is an individual decision and does not require the jury to be unanimously. That has to be unanimous. This could be misread into believing that the death sentence does not have to be unanimous. And I would find that to be a misstatement of the law.
Yeah.
So, okay. Yeah. Did Toledo get to you?
No, Judge, this would be at the, that's not written the way I was written. I'm going to bring that back to you tomorrow.
Of course, you know.
Jeff, we're all singing better in the shower, buddy.
This would be at the end of that paragraph, which is number 4.
Yeah, I got it.
Your verdict to recommend life does not require a decision to be unanimous once any one of you decides not to impose the death penalty. A unanimous verdict for either life or death.
See that-
A non-unanimous.
And
Do you think I can articulate about that as well again?
see, I think you're going to confuse them.
A unanimous verdict for either life or death, or a non-unanimous verdict for life, or all permissible verdicts. That's not confusing.
How many times did you just have to read it to get it right?
Well, that's because you all have their own.
I just more than other than me.
That's really not fair at all.
The verdict to recommend life does not require your decision to be unanimous once any one of you decides not to impose the death penalty.
If how about if I just say that first sentence, your verdict to recommend life does not require your decision to be unanimous once any one of you decides not to impose the death penalty. And then
See, I would,
a non-unanimous verdict for life is a permissible verdict.
I don't like it. I wouldn't be inclined to give it. I guess I'm speaking now poorly. I'm denying it.
There's no instruction on here. There's not one.
Yeah, I know what you're trying to say.
There's not one instruction that says a non-unanimous verdict for life is permissible. That doesn't say, it's not saying anything.
I think it should read like the verdict instruction for the guilt phase. Your verdict may be a unanimous verdict, recommendation, or not recommendation, sentence of death. B, a unanimous decision for life. C, a non-unanimous decision for life. It should be 3 separate. To put it in one sentence, it's going to confuse. You know, your verdicts in this case are, you know, as follows as far as, you know, whatever they use in the guilt phase.
I just want it perfectly understood, because it's not in here anywhere, that a non-unanimous verdict for life is an absolutely legal verdict. So how would I say that? It's not. Not in it.
It says anything short of a unanimous verdict is a life sentence.
Yeah, that's in there.
Right.
And it's also, in the guilt phase, instruction is kind of the same, but it does have that one explanatory, kind of one paragraph saying, hey, these are the choices, A, B, and C. That's what we're looking for. I mean, it's not harmful to explain to them, there are 3 possibilities here. There is unanimous death, unanimous life, non-unanimous life. Those are the three only possibilities. I can't, yeah, well, I wish you typed it up. Let me do it right now, just so I won't forget.